You are listening to Based in Fact, a true crime podcast. Join hosts Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 3 of Based in Fact, a true crime podcast. I'm your host, Lisa O'Brien. Kyle is away tending to some family business. And I'm joined by guest host today, Jennifer Harmon, a well-known community advocate and alert neighbor captain in Midtown Tulsa. Born and raised in Tulsa, Jennifer is a Navy veteran and holds a Master of Divinity from Phillips Theological Seminary. Jennifer co-founded Justice for Peggy Guyton in 2011. We are at episode 15, State of Oklahoma versus Phillip Dean Hancock. Hancock's November 2023 execution was preceded by controversy, including claims by our least favorite Oklahoma legislators, one former and one current, who claimed that Hancock was exercising his God-given right to defend himself when he brutally murdered two men, both of whom were unarmed and posed no threat to him. We'll look at the 2001 murders of Robert Jett Jr. and James Lynch III, the evidence against Hancock, his trial, direct appeals, and state and federal post-conviction claims, including an effort to use DNA testing to prove his claims of self-defense. Then we'll talk about the Oklahoma Pardon and Parole Board recommendation for clemency, Governor Stitt's last-minute denial, and Hancock's execution on November 30th, 2023. And good afternoon, Jennifer. Thank you so much for joining me.
Good afternoon, Lisa. I'm honored to be here. Thank you for asking me to sub in for Kyle. I hope everything's well with him and his family.
Yeah, he has a family. He had a family obligation today, and so he was not going to be available. And I was like, well, Jennifer, you were part of the story, so.
I was down there for the dog and pony show. Yes. So why not?
It was a no-brainer to invite you on, and I'm so glad you were available.
Thank you very much for having me.
You almost got the last-minute invitation last Sunday because Kyle was ill.
Oh.
And then I thought, no, I can't call you or I can't reach out to you like 40 minutes before we're supposed to start recording and say, what you doing? So I decided to postpone for a week.
That's okay. I'm welcome to sub anytime, and especially if it's an Oklahoma case, which the Oklahoma cases seem to have garnered a lot of media attention as of late. So, yeah.
So, all right, well, let's get started. And, of course, we always start with the victims. Not a lot of information available about them, unfortunately, because they were early in the internet age, and there tends to be a real dearth of information about victims, no matter what era we're talking about as far as crimes go.
Right.
So we've got Robert Lee Jett Jr. He was born on February 12th, 1963. His parents are Robert Lee Bob Jett Sr., who was born 1932 and passed in 2018. And his mother was Joan Yvonne Dagley Jett, who was born 1936 and passed in 2015. His mom was Joan Jett, but not the same Joan Jett.
Wow.
And they were both from Morgan City, Louisiana. Now, I don't know where Robert was born, but I believe his father worked in the oil industry in Oklahoma.
Oh, okay.
So he may have been born in Morgan City or in the Louisiana area, and he may have been born in Oklahoma. It's not really clear.
Right.
He had siblings. Robert had siblings. The first was Dana Lynn Jett, who was born and passed in 1961. That was 2 years before Robert was born. He had a sister, Roxy, and a brother, Ryan. He was married to a woman named Sandra. They were divorced, and his cause of death was multiple gunshot wounds. Then there's James Vincent J.V. Lynch III. He was born October 22nd, 1943. He had a sister, Caroline, and he had two nieces, Taylor D. Lynch, who was born in 1989 and died in 2013, and another niece named Kayla. And his death was also multiple gunshot wounds.
Yeah.
And then we have our perpetrator, Phillip Dean Hancock. He was born February 15th, 1964 in Oklahoma City. His birth father was David Harold Atlee, who was born 1939, died in 2018. His mother was Davida Ann Dee Dee Greenlee Atlee Hancock Kerr. She never gave up on love. And his parents were married from 1963 to 1977. His step parents were Alan M. Al Hancock, and Mr. Hancock died in 1995, but Philip actually adopted the Hancock last name. And then he had another stepfather, John Sidney Kerr, who married his mother in 1998. And he was born 1934, died in 2015. And then he had a stepmother, Kathleen Joyce Kelsey McCarthy Atlee, who married his father in 1978. He has a brother, David Craig Atlee, who was born in 1968. David is severely disabled. He had, I think, cerebral palsy.
I think
and
so.
Philip did help take care of David, most of David's life. David, I didn't find any evidence suggesting David is no longer with us. But he's now, he still has his mother because his mother's still alive.
Right.
He was married to a woman named Julie from 1990 to about 2000. He had stepchildren from his relationship with Julie. His emotional, mental personality, I guess. He used drugs and abused drugs. He was a perpetual victim, and he had anger issues.
Yeah.
Which all culminated in what led to him finding himself on death row.
Right.
His criminal history included a first-degree manslaughter committed on May 26, 1982. He had an assault and battery with a dangerous weapon on September 3rd, 1992, concealing stolen property October 22nd, 1992, possession of a controlled dangerous substance with intent to distribute, and December 22nd, 92, actual physical control, which I think involved a vehicle with a DUI interlock device.
Yeah.
In June of 1998. And then he had, on October 6, 2001, 6 counts of unlawful possession of a controlled dangerous substance with intent to distribute, possession, furnishing of a precursor substance, possession of a firearm by a felon, possession of a firearm while in the commission of a felony, unlawful possession of a controlled drug with intent to distribute, and unlawful possession of drug paraphernalia. He also had 2 counts of assault and battery and possession of contraband by an inmate while in jail on October 10th, 2001. And then on October 3rd, 2002, because Philip just is not that smart, he escaped from custody.
Right. Yeah.
His victims were Charles Lester Warren, who was born in 1954 and was killed by Hancock in 1982 in what became his first-degree manslaughter case. In that same incident, Hancock also injured Karen Barber and William Orr, which to me says that it wasn't really manslaughter. It was murder and attempted murder, 2 counts. And then on the victims that we're speaking about today are Robert Lee Jett Jr. and James Vincent J.V. Lynch III.
Right. And now, I don't know when the charges from October 2001 and the escape from the jail. He
That
killed Mr. Lynch and Mr. Jett in April of 2001.
correct.
Yeah,
April 27th.
correct. And so I'm not sure.
That was in Logan County.
Yeah.
He hot-footed it out of Oklahoma County
Okay.
and he went to Logan County.
I got
And then he was caught with the controlled dangerous substance because he was into meth
sure. Right.
and got arrested. And then he assaulted somebody in jail and had contraband. And then in April, he had pled guilty and then decided that he didn't want to be in jail. So he escaped from custody because he was, we'll get into this a little bit later.
Okay.
But he was sentenced to some local jail time before he was going to go to ODC.
Okay. Yeah. That's what I was wondering was.
Yeah.
But then I remember looking at the case files that it really wasn't until he, I think, escaped from custody. It wasn't until after that or something that once he got caught and sent back to Logan County, if I'm correct, that's when he either admitted or it came out that he's the one who killed Mr. Jett and Mr. Lynch. Is that
Correct.
right?
Correct. We'll get into that a little bit more later.
Okay.
So the crime occurred at 2324 Southwest 31st Street, which is in Oklahoma City, Oklahoma. Of course, Oklahoma County. The victims were Robert Lee Jett Jr. and James Vincent J.V. Lynch III, who were 38 and 58 respectively. Mm-hmm. Bob Jett was a drug dealer with potential ties to motorcycle gangs and a collection of weapons in his home. Little is known or reported about J.V. Lynch other than the fact of his death and how he died. Hancock chose to associate with Jett in spite of his alleged reputation, likely because Hancock used meth and Jett had a reliable supply. Right. On April 25th, 2001, Hancock and his girlfriend, Catherine Quick, had a falling out over her intravenous use of meth. She wanted to leave their shared residence, but Hancock wouldn't let her drive. Jett came to her rescue, picking her up and bringing her to his small house on Southwest 31st Street. Quick slept on Jett's couch that night and early the next morning woke to find Hancock had let himself in while Quick, Jett, and his ex-wife Sandra were still asleep. Hancock claimed he was there to retrieve the cell phone Quick took, but more likely than not, he was there to try to win her back.
Right.
When Quick refused to reconcile with him, Hancock left. He will never admit that he spent the day fuming about her refusal. That evening, Hancock reappeared on Jett's doorstep, again letting himself into the house and helping himself to a cigarette from a closed pack he found in the living room. He claimed he was there to pick up Quick, who'd left that morning. Instead of leaving, Hancock stayed, hanging out and doing drugs with Jett Lynch and Sean Tarp, a woman summoned to the house by Jett to settle a debt that night. Jett was working on a motorcycle in the living room, in the room called the Harley Room. Things weren't going well, and he was, according to Tarp's trial testimony, frustrated. Tarp also sensed tension between Hancock and Jett. She believed that they'd had a falling out because Hancock stated he was trying to work things out. And just as an aside, I think Hancock was a very annoying person. Probably. That nothing was ever his fault.
Right.
And so when you called him on him doing something wrong, it wasn't his fault. He let himself in the house because he heard somebody say, "Come in." Or he asked if he could have a cigarette and you said yes.
Right.
So just to set the stage here a little bit.
Yeah.
Jett's frustration with his work on the bike bled into his interactions with Hancock, and he confronted him about entering the house uninvited that morning. Hancock claimed to have heard someone invite him in, but that's unlikely given that Quick, Jett, and Sandra were all asleep when he made his entry. Hancock had laid claim to a pair of sunglasses he believed to be Quick's and testily claimed those as his own. After a cell phone call, Jett's mood deteriorated and he announced that he was going out for cigarettes. When he found the open pack in the living room, He blew a gasket over Hancock's claim that Jett had given him permission to open the pack. Jett threw his jacket off and angrily ordered Hancock into an empty cage, allegedly used to house an iguana. Now, I've seen pictures of that cage, and I didn't see a door where anybody could get into it.
I didn't either.
Yeah. I don't know how that was supposed to happen. I guess maybe go stand still and we're going to pick the cage up and put it on you. I don't know. There is no dispute that Jett at some point brandished a metal bar when he ordered Hancock into the cage. There's also no dispute that Jett was carrying a pistol. Tarp's testimony soundly contradicted Hancock's claims about the brief altercation and the role JV played in it. According to Tarp's testimony, Hancock did not obey Jett and instead attacked when Jett advanced. Hancock quickly gained control of the pistol and began firing, striking Jett twice. Jett fled the house, escaping into the rear yard. Hancock then shot JV twice, fatally wounding him. Next, Hancock pursued Jett into the backyard where he stood over him and shot him twice more. Hancock went back into the house where he encountered Tarp, who'd come out of her hiding place in the back bedroom. Miraculously, he let her live and fled in his truck, dropping the tailpipe from his exhaust system at the crime scene. Tarp didn't know Hancock's name, so she was unable to identify him to police. They released a sketch of the suspect, which went nowhere. It was only after Hancock was arrested and incarcerated on other crimes in Logan County, Oklahoma, that he was linked to the murders. The exact forensic evidence that linked him isn't clear, but it was likely Jett's gun that Hancock kept after he murdered Jett and Lynch.
Right.
The gun was in Hancock's possession when he was arrested in Logan County.
That's right.
And then, as you pointed out, when that connection was made and the investigators came to talk to Hancock, that's when he admitted to what had happened and told the story of the assault that he was just defending himself from.
Right, and I'm sure you'll get into this later. He actually tries to bring up the gun as a double jeopardy thing in one of his briefs. Yeah.
Yes. That was one of the areas of his direct appeal because he'd been criminally charged with possession of the gun in Logan County.
Yeah.
So, okay, so he this is his prior criminal history. He had a jury trial on October 21st, 1982, and he was convicted of first-degree manslaughter and sentenced to 4 years imprisonment. In June of 1993, he had a jury trial on the charges of, the assault and battery with a deadly weapon, and that was an acquittal. And then on August 3rd, 1993, he pled guilty to possession of a controlled deadly dangerous substance with intent to distribute and received a suspended sentence. And he had another plea on September 20th, 1993 to concealing stolen property. That was another suspended sentence. Revocation was sought in 1995, but it apparently didn't go anywhere. On October 8th, 1998, he pled guilty to actual physical control. On March 26, 2002, in Logan County, he pled guilty to unlawful possession, furnishing precursor, possession of a firearm by a felon, possession of a firearm while in commission of a felony, unlawful possession and of a controlled drug with intent to distribute, and unlawful possession of drug paraphernalia. On those charges, he received 15 years in DOC, $1,000 fine and court costs, 10 years in DOC on count one, and count one was the $1,000 fine. Count two was 15 years in court costs. Count three was 10 years in DOC plus court costs. And then count 4 and 5 were 15 years in DOC plus court costs. On count 6, he had 1 year in Logan County plus court costs. And apparently they said, well, let's let him serve the 1 year first. And on the 26th of March, he also pled guilty in the assault and battery and possession of contraband while in jail. And he got another 90 days in Logan County plus court costs. And then on count 2 to 5 years in DOC plus court costs. On April 3rd, 2002, he escaped from custody.
Okay.
And then there's a cute little story in the newspaper out of Guthrie, Oklahoma on April 8, 2002. The last of 4 inmates who escaped from the Logan County Jail earlier this week has been recaptured. Phillip Dean Hancock, 38, was taken into custody about 11 p.m. Friday after authorities received a tip that he would try to pick up a vehicle in the parking lot of an Edmond movie theater, officials said. We had found out that someone was supposed to drop off a truck for him at Edmond in the parking lot, so we just set up on it, said Logan County Sheriff Randy Richardson. When Hancock arrived to pick up the truck, officers from Logan and Payne counties, Guthrie, Stillwater, and Midwest City were waiting. Hancock was arrested without incident, Richardson said. So he was arrested, and it was in July of 2002 that the connection was made between Hancock and the murders of Robert Jett and James Lynch. And he was charged by information on July 2nd, 2002, with 2 counts of murder in the first degree, pointing a firearm at another, and possession of firearm in count 4.
Okay. If I may interrupt you, this is probably the best time to insert this basic general fact about, okay, so on his priors in 1982, 93, and 93, it looks like the prior criminal history, he was charged in Oklahoma County.
Mm-hmm.
And that would be, and that was when Bob Macy was the district attorney for Oklahoma County. Bad Bob Macy, that the media loved to portray as the evil district attorney.
Right.
So Bob Macy was the district attorney for the 1982, where he only got manslaughter in 4 years. And he was acquitted in 93. And the other thing, he got a suspended sentence. So maybe Bob, Big Bad Bob, had a soft spot in his heart for Mr. Hancock during this time. But to be clear, Bob Macy was not the DA when Phillip Hancock was charged with this double murder in 2002. He was the district attorney and then retired in June of 2001.
Right.
And if I hear another media outlet report about one of our bad death penalty cases, and it was done during the time of Big Bad Bob Macy, my brain is going to explode, because that is patently false. And if he really
that
was
is an excellent point.
So really such a bad guy, then I would think that in 1982, it wouldn't have been first-degree manslaughter and 4 years in prison.
Well, you have to remember, he was not first-degree manslaughter, I believe, was a lesser included offense.
Right.
And that is what the jury convicted him of.
Right.
I believe he was facing murder charges.
Right, but if Bob Macy was so bad, he wouldn't even allow the lesser charge. You get where I'm going with this.
Well, he doesn't have any control over the lesser charge.
Yeah.
Hancock testified, and it's the judge who decides
whether
the lesser charge has been potentially proven or not.
Correct.
So
I think
what happens is the DA can charge first-degree murder. But if during the course of the trial, the defendant testifies and convincingly puts forth a case for manslaughter or negligent homicide or whatever lesser degree, even of murder, then the judge can charge the jury with those potential. You can kind of amend the indictment to charge those crimes.
Right. And I bring that up because in our local and national media, I mean, I'm just quoting what they always say for Glossop and Phillip Hancock. They'll say during the trial, which in both cases was after Bob Macy had retired.
Mm-hmm.
One says, during the 2004 trial, the district attorney was Bob Macy, and advocates like McDougall, today's conference, say his scandal-plagued era. Well, he wasn't the DA at that time. He wasn't the DA after and during Phil Hancock's trial. And so it's just patently false for the media. I know it's good filler, but it's really wrong to do that. And
Mm-hmm.
I just
Totally agree.
to point out who was and wasn't the DA during his time of Hancock's criminal life.
The charges that Hancock faced for the murders of Bob Jett and J.V. Lynch had nothing. Macy had nothing to do with those. It was another DA by that point.
Right. It
because
was
he wasn't identified until 2002, and Macy had been retired for over a year by that point.
Right.
So, and then finally we have the escape from custody charge was dismissed on October 7th, 2003. And then there was a second dismissal in 2023. So they didn't really pursue the escape charge.
Right.
All right. So then we go to the pretrial period. That was in district court in and for Oklahoma County. The judge was the Honorable Susan P. Caswell. Case number was CF-2002-3562. Hancock was represented by John W. Coyle, I believe Jr. and Sr., Kent Bridge, and Tamara Spradlin. The state was represented by Cassandra Williams. Now, when there's a lot of criticism of Hancock's trial attorneys.
Right.
But let me tell you, people, Hancock's trial attorneys on September 11, 2003, filed over 70 motions and objections.
Exactly.
Challenging the case against Hancock right out of the gate.
Right.
There were so many motions that I could not even list them all.
Yeah.
It was too arduous a task. I mean, that's a lot of challenges and objections. And one of the objections was to the death penalty.
Right. They were working hard for him.
Mm-hmm. And they had hearings on those defense motions October 28th and October 31st. An order was entered on May 10th, 2004, granting a motion to examine evidence by Hancock's defense expert. They filed additional pretrial motions on June 1st, July 30th, and August 6th of 2004. There were 5 motion eliminees filed in September of 2004 by Hancock, and then a hearing was held on state and defense motions in limine on September 10th, 2004. And Hancock's case was also set for trial 2 or 3 times in 2003 and early 2004.
Right.
And the trial was continued.
Right.
Either at the request of Hancock or the state. The trial commenced on September 13, 2004. Counsel for the state was Cassandra Williams. Counsel for the accused was John W. Coyle III and John W. Coyle IV, Kent Bridge, Tamara Spradlin, and C. Merle Guile. The trial, phase 1, went from September 13th to September 24th. Hancock was found guilty on counts 1, 2, and 4 on September 24th, 2004. And then the penalty phase 2, was held September 24th to September 29th. On September 29th, the jury came back with a sentence of death on counts 1 and 2. On October 25th, 2004, they did formal sentencing, and that was death warrants were issued on counts 1 and 2, and Hancock was sentenced 10 years on count 4, and the court filed its summary of facts.
It's my understanding the reason why they were a death penalty qualified jury, and so in the sentencing phase, they heard the mitigating and the aggravating factors. It's my
Correct.
understanding he met 4 of 6 aggravating factors, and that's why.
Correct.
Okay, that means, and correct me if I'm wrong, they have to find evidence kind of in the trial, just like in the trial, there has to be certain evidence of these specific factors for them
Correct.
to even be able to consider a death penalty. So it's not just some arbitrary thing they came up with.
Right, exactly. And they have to find the aggravating factors beyond a reasonable doubt.
Yeah.
They don't have to find mitigating factors beyond a reasonable doubt. And then they have to weigh whether the mitigating factors outweigh the aggravating factors. And in this case, the jury found those mitigating factors did not outweigh the 4 aggravating factors they found. And I think the aggravating factors that it's probably listed in the direct appeal were risk of harm to more than one person, future danger
to society.
Yeah, continuing danger to society, that he had committed prior violent crime.
Yeah.
And I can't remember what the 4th one might have been.
I don't know, but I do recall seeing in the case files that you sent me that it's somewhere in one of those, when they considered the mitigating factors, the testimony or the evidence of his life caring for his brother was actually pretty powerful as a mitigating factor, but it just simply did not outweigh.
Correct.
That here is a guy that you can't even put in prison for life. He will kill again if he's not.
Yeah. So he also, on the same date, October 25th, 2004, an acquittal was entered as to count 3, which was pointing a firearm at another.
Mm-hmm.
On October 27th, Hancock filed his notice of appeal. He went into the direct appeal process. He was represented by Madeline Cohn, Jamie Pybus, John Coyle III, John Coyle IV, Merle Guile, James Lee Hankins, and Lenita Henriksen. The state was represented by the Oklahoma Attorney General and Oklahoma County DA. Again, the notice of appeal was filed in Oklahoma Court of Criminal Appeals. The docket number assigned was D-2004-1097. His brief was filed on November 23rd, 2005. And that included an application for an evidentiary hearing on Sixth Amendment claims. So even in direct appeal, he was challenging the representation of his attorneys.
Right. Yeah.
So that doesn't sound, he's got his trial attorneys who threw every multiple conceivable motions at the court.
Mm-hmm.
And then you've got his trial attorneys who are challenging, his direct appeal attorneys rather, who are now challenging the performance of his trial attorneys.
Right.
So, all right, the propositions raised by Hancock at trial, on direct appeal rather, were as follows. He raised a sufficiency of the evidence claim, and he argued that proof failed to show intent to kill. His claim of self-defense was never disproved beyond a reasonable doubt, and at most he was guilty of manslaughter by killing in a heat of passion or resisting criminal attempt. Proposition 2, that the admission of his 1982 manslaughter conviction was improper, and that was actually admitted by his attorneys.
Right. I mean, someone elicited it during trial, and so they had to go there.
Yeah.
They were allowed to go there. So
then there was proposition, and these are not in numerical order because I cite them the way they appear in the direct appeal opinion. His next proposition of error was exclusion of his hearsay statements to a defense witness, which were about the facts of what happened, or what Hancock alleged happened. Then he had challenged the exclusion of evidence that Jett and Lynch were affiliated with notorious motorcycle gangs. His next proposition, exclusion of 2 defense exhibits after the state used portions of the documents to impeach Hancock which he claimed violated his due process rights. He alleged instructional errors and misleading arguments in the jury instructions, claiming that they denied him his right to self-defense by an aggressor, or rather, the jury instructions addressed denial of right to self-defense by an aggressor, withdrawal of an aggressor, and the right to self-defense in circumstances of mutual combat, and that menacing words are not sufficient to trigger the right to self-defense. Failure to tailor the instructions with Hancock's perceived facts of the case and prosecutorial misstatements of law in closing argument compounded the instructional errors.
Okay, let me wait. So
sure.
In this one, the right, in part where it says the right to self-defense in circumstances of mutual combat and menacing words are not sufficient to trigger the right to self-defense. Is that
right.
what the actual documents say? Because why would you have your attorneys state that? Because
again, it's the judge who ultimately decides on what the proof shows.
Yeah.
And so in this case, the state challenged Hancock's self-defense claim.
Okay, I got you.
And Sean Tarp's testimony basically said that once Hancock got control of the gun, he became the aggressor.
Oh, okay. I see. This is under instructional errors. Okay, now
right. So basically, Hancock's arguing that the jury should never have been given those instructions.
Gotcha. Thank you for that clarification.
Even though that's what the proof showed. And again, that's, the judge determines what the proof is shown and what jury instructions to give. Of course, both sides submit the ones they want, but ultimately it's up to the judge.
Right. Okay.
He next claimed that the flight instruction violated his state and federal due process rights. And then in his next propositions of error, he alleged ineffective assistance of counsel, which included claims about the eliciting the fact of Hancock's 1982 manslaughter conviction on direct examination, which I believe was, in legal terms, sometimes when you have a turd and you know it's going to come out, instead of waiting for it to come out on cross-examination,
right,
when it can make your client look really bad, and this is in situations where your client is testifying, what you do is to try to deaden the impact of that turd. You ask that question and get it out of the way early in your direct examination.
Got it. Yeah. Okay.
And it also helps your client's credibility because, it's a turd, but they're openly talking about it, and they're giving you the facts about it up front.
Right.
So that actually is not a bad strategy, and it's a common strategy with attorneys.
Well, right. The optics of it in front of a jury would be, well, they owned all of this. He owned those things. So maybe it really did happen the way he said it did.
Right.
Okay.
So then his next claim was failure to object to the prosecutor's misstatements of law and evidence in closing argument, failing to properly articulate the proper exception to the hearsay rule for Hancock's statements to Gould, who was the witness who was going to repeat statements Hancock had made to him, which were self-serving. Failure to call a police detective to testify to the biker reputation of Jett and Lynch. Failure to properly utilize available evidence of a 911 call and police reports to impeach state witnesses who reported the shooting. Failure to utilize available expert testimony and cross-examination to corroborate Hancock's version of events. And failure to use a photograph of Jett's AR-15 to corroborate Hancock's claim that he believed Jett might be going for another weapon. And then also the conviction in count 4, possession of a firearm after former conviction of a felony violates double jeopardy on the argument that he'd been convicted of possession of the same gun in Logan County.
Right.
But on a tangent, theoretically, the possessions were 2 different times.
And the
first possession was in Oklahoma County, when he committed the murders, and the second was in Logan County when he was arrested, or at the time of his arrest. So,
and average Joes like me would just call that karma.
Yeah. And then his last 2 propositions were: the evidence is insufficient to prove the aggravating circumstance of heinous, atrocious, or cruel. That was a 4th factor. The evidence supporting the continuing threat, aggravating circumstances constitutionally overbroad, and the jury instructions failed to limit the sentencer's discretion as required by the 8th Amendment. And then his final error, which was proposition number 13, so his direct appeal attorneys weren't exactly snoozing, was cumulative error.
Right. So real quick on this one, this proposition, the one that said the evidence is insufficient to prove the aggravating circumstance of heinous, atrocious, or cruel. I think this will probably come up later. This was one of the reasons why the Cowboy Posse said this was self-defense, because there was nothing heinous about these murders.
Well,
that's what they
can see it that way, but shooting a guy 2 times, shooting another guy 2 times, and then following guy number 1 into the backyard and shooting him 2 more times while he's laying on the ground begging you not to kill him.
Right.
That is where it comes into heinous, atrocious, and cruel. And I think J.V. Lynch's physical disabilities and poor health made it heinous, atrocious, and cruel, because J.V. Lynch was no threat to Phillip Hancock.
Correct. Exactly. So it is really, I mean,
I frankly am surprised he didn't murder Sean Tarp as well. And then just say she jumped on his back and was trying to, hold him down. Because she had seen him, but I guess maybe he thought, well, she doesn't know who I am, so she can't tell anything. I don't know. But I'm kind of surprised he didn't kill Sean Tarp.
In that world, and listen, I don't care if you want the biker gang in there or not. The problem with getting all of that kind of stuff in is you rolled with those people.
Exactly.
So it's kind of, but it's not the biker gang part. It's because there are biker gangs who don't do crimes and deal drug stuff. So it's really just about a life of drugs and dealing drugs and doing dope. And those are scenarios where you're never going to get all the facts straight, but you're going to be able to extricate what you need to from it. And apparently the prosecution was able to do that miraculously. And how Tarp is still alive surprises me as well. And yet it doesn't, because, the druggies and the manipulators and the consummate victims, they always got to leave someone around to manipulate.
Right.
So
that possibly is. But he didn't know her, so he really couldn't effectively manipulate her. And some more stuff will come out in the post-conviction period. Anyway, the state filed this appellee brief on February 10th, 2006. The case was submitted on the 16th of February. Oral argument was held October 24th, 2006. Hancock filed a supplemental authorities on October 31st, and then the appellate court issued its opinion on March 9th, 2007, and they held that the judgment and sentence of the District Court of Oklahoma County in counts 1 and 2 is affirmed. Count 4 is reversed and remanded with instructions to dismiss pursuant to Rule 3.15 Rules of Court of Criminal Appeals, Title 22, Chapter 18, 2005. The mandate is ordered issued upon the delivery and filing of this decision. So basically, they dismissed and denied every one of Hancock's propositions of error.
But the number 4.
Count 4, they reversed and remanded they agreed that the possession, that he'd been convicted in Logan County of possession, and therefore convicting him again in Oklahoma County, basically a possession of the same gun, would violate double jeopardy.
Oh, see, it says, I'm looking at in the Proposition 4.
No. Count 4 was the count of criminal charges.
Gotcha. Okay.
Yeah. And then Judge Lumpkin, who I'm really beginning to like, the more I do research into these Oklahoma cases, I really am beginning to like him a lot.
Mm-hmm.
He issued a dissent. He said, in Proposition 10, I find appellant's conviction in count 4 was not barred by double jeopardy. Appellant possessed the weapon on different dates in different counties. Criminal charges could lawfully be brought in both counties, as venue of the crime is a different element in each prosecution. As these were two separate offenses, jeopardy did not attach upon appellant's conviction in Logan County, and his conviction in Oklahoma County was not in violation of the prohibition against double jeopardy. Accordingly, I would affirm the conviction in count 4.
Right.
The mandate issued on March 9th, 2007. He did file a writ with the U.S. Supreme Court. He got an application for extension of time filed on July 9th, 2007. That was granted to give him until September 21st to file his petition for relief. He filed that on September 21st. Respondents filed a brief on October 9th. A conference was held on November 9th. And the order was entered denying his writ on November 13th, 2007. So his conviction and sentence became final on November 13th, 2007. Now he goes into the state post-conviction phase.
And so up to this point, then, just for the lay people like myself, you're what you've just gone through is strictly post-conviction direct state appellate stuff.
Correct.
And so for people that don't understand why all this time and why it's so frustrating, that's his attorneys working hard for him, filing as much as they can, throwing it whatever they can to see what sticks. And we haven't, that's just right after the trial within a couple of years. So now you're getting ready to get into what's really going to take a long time.
Correct. And that's the collateral attack.
Okay. Yeah. Okay.
The direct appeal is the direct attack, and then the collateral attack on the trial and trial process.
Right. These are now you're getting into procedural things.
And we see some of the claims, and some of the same claims will come in state post-conviction and federal habeas. But overall, we do see some of the same claims because what might not have been sufficient on direct appeal to prevail, but it might work on state post-conviction or federal post-conviction.
Right.
All right. So the attorneys for Hancock were Ruth Adams Warnicki, Kevin Hunter Pate. He was represented by OIDS, Julie Gardner, and Brant M. Elmore. The jurisdiction venue was the Oklahoma Court of Criminal Appeals, PCD-2004-1265. His initial filing was on December 17th, 2004. So his direct appeal attorneys filed the initial filing for him. And then an application for post-conviction relief was filed on February 4th, 2007.
Right.
So 3 years later, after his right before his direct appeal concluded. And it varies from state to state. I think Oklahoma is one where you can have tandem direct appeal, state post-conviction going on at the same time.
Okay.
Other states, you finish your direct appeal and then you start state post-conviction. So it varies from state to state.
Right.
So his claims in post-conviction were the well, I want to go into them because I think it's really important that we know what he was claiming, because a lot of stuff that he's claiming is what they claimed exonerated him in 2023. So he claimed the district court committed error during the voir dire process by improperly defining the word consider in relation to whether potential jurors could fairly consider all three punishments for first-degree murder, disqualifying certain potential jurors over defense objection while seating jurors who were biased in favor of the death penalty. Trial counsel was ineffective in failing to object to these errors. His next proposition was the district court harbored an unconstitutional bias against petitioner, resulting in an unfair trial based on the OCCA's statements concerning Judge Susan Caswell's conduct in other cases and statements made in her judicial campaign, as well as certain rulings in this trial as evidence of bias. Proposition 3, the state violated its constitutional rights by intentionally failing to preserve two cellular telephones recovered from the crime scene in violation of the principles of Brady versus Maryland and Arizona versus Youngblood. Proposition 4, the district court should have instructed jurors that petitioner must serve 85% of his sentence for murder in the first degree, relying on 21 OS 13.1, 2003, and our decision in Anderson versus State. Proposition 5, trial counsel were ineffective for failing to impeach the eyewitness with prior inconsistent statements, failing to impeach the medical examiner with findings from the autopsy report, failing to impeach a second stage witness regarding the reasons for his termination from the Logan County Jail, failure to subpoena cell phone records of Robert Jett, failing to ask petitioner whether Robert Jett had a reputation for violence, failing to request an instruction on mitigating circumstances relating to the victim's involvement with drugs, weapons, and motorcycle gangs, failing to object to the improper admission of victim impact evidence, failing to object to admission of photographs of the victims in life, failing to inform petitioner of conflict of interest arising from defense counsel's marriage to an assistant district attorney, failing to object to the district court's removal of certain jurors for cause, failing to request an instruction on the meaning of a life sentence with parole, and failing to object to improper photographic evidence. Petitioner also claims that appellate counsel rendered ineffective assistance by omitting these meritorious instances of trial counsel's ineffectiveness from the arguments advanced on direct appeal.
Wow.
Yeah.
That's a lot. That's a lot of work.
Yeah.
That's a lot of ineffective assistance of counsel working there for you. Right.
Proposition 6, the prosecutor's remarks denied him a fair trial and sentencing by demeaning his mitigation evidence, commenting on his lack of remorse, and improperly defining reasonable doubt. And then Proposition 7 was cumulative error denied him a fair trial and sentencing.
I mean, in this part, he all but the only thing that's left out of this about what they did and didn't do, or is he looked at me wrong or he winked at me, therefore I should get another trial. Yeah. I mean, they threw everything out there.
Mm-hmm. Yeah. He also filed motion for discovery and motion for evidentiary hearing and an appendix in support of his application. On the 9th of February 2007, the state filed an opposition to his application for post-conviction relief. And I just want to point out here, the state had 5 days to prepare the opposition to his application.
Oh my gosh. I did not know that.
Now, it may have been generally in a case where there's not really set rules or deadlines. The sooner you get it filed, the better.
Right.
But, I mean, that's like they weren't even ordered to do it in 30 days. They did it in 5 days.
Wow.
So, when we talk about unfairness, sometimes I think the state and the prosecution gets the short end of the stick because sometimes they have only, a matter of days or maybe a week to get something filed in opposition to the latest effort.
Right, as is the case that happened. We don't have to go down this rabbit hole, but that did happen with Glossop and some of the first filings with our new attorney, and in this before the Supreme Court. I think the victim's family, at the time they finally got representation, that there was a ticker that was ticking, and it was a very brief period of time that they had to get something in. Yeah.
Correct. All right. So the Court of Criminal Appeals took a year to consider all of Hancock's claims.
Wow.
And on February 6, 2008, they denied him relief. But I'm gonna go into why they denied him relief, because I think it's really important, because we've seen it, and we've seen it in the news with Robert Robertson.
Yes.
Everybody claiming the courts aren't doing what they're supposed to be doing. The courts are rubber stamping. The courts are not giving a fair hearing. The courts are denying due process. Well, they considered Hancock's claims for a year.
Exactly. Sure.
So that means they went through the underlying trial record.
Right. I mean, we have in our state our own independent, I don't know, whatever, appellate procedures that our state court, or what is it, our OCCA, they have to follow this. I think it's what, 22 OS?
Yeah.
1089.
22 OS, yeah.
Yeah, that takes a long time to go through all of that. And yeah, that's why people need to read and listen to your podcast. They need, so that they can really understand.
I just wish they'd read the actual appellate opinions word for word.
Yeah, because that's where you get all the meat and bones.
Mm-hmm.
In my opinion, you're going to get two sides to the story and the trial stuff, but you're going to get a general understanding. But you're going to get the application of the law and how it works and how the justice system works, I think, when you read the appellate brief stuff.
Mm-hmm. Yeah. And well, and another comment I made before, I think a lot of people don't understand what due process means. They think due process means you present it and you win.
Right, exactly.
When in reality, all due process means is you have the opportunity to present it.
Exactly. Yes, the door was open for you to submit this. You took advantage of it or you didn't. Sometimes the door was open and you presented something that was already procedurally barred. So if you missed the time window, that's tough. That's
right.
That's how the system works. That doesn't mean it's broken. You got your due process. And that's part of the problem with the death penalty, in my opinion, is the amount of time for this due process seems to have permits far too much of being able to submit different applications of new, now that it has to be
re-arguing and trying to say, well, this is new evidence when it's not.
Right. They're trying to relitigate and just reify different things. It's something that I find very frustrating. And as a taxpayer, I don't like paying for it either.
Mm-hmm.
But it shouldn't be such a long. That's the only thing I think is broken about our state system is the length of time that it takes. And I don't think that, well, Oklahoma voters clearly didn't take that into account because 66% of them in 2016 voted that we keep the death penalty. So that's what it is in our state. And so this is what we have. This was what we're doing and using.
Right. So. All right. So let's go through the opinion. Proposition 1, the court found that because the facts underlying the related allegation of trial counsel's ineffectiveness were reasonably ascertainable at the time of the direct appeal, post-conviction review of the ineffectiveness claim is procedurally barred.
I think that
Proposition
I
1
think
provides no grounds for relief.
I think that one is very important, and that's another reason why people should read, like you follow your lead and read these briefs, because things that were reasonable, a lot of times when you get in late in the game, 20 years down the road on these death penalty cases, you see that the filings they're making, the courts come back and they say, no, this was something that you could have ascertained from day one.
Mm-hmm.
But I think that appellate attorneys are using this, it's like a way of buying time and pushing the execution date further down the road.
Correct.
They know it was reasonably ascertainable, but they're still going to throw it up there on the wall and see if they can get it to stick. Yeah. And that's the part where the unfairness comes into, I think, the victims' families.
Correct. Totally agree. All right. Proposition 2, this was the alleged bias of the trial judge, clearly could have been raised in prior proceedings, but was not, which they direct you to see first Mitchell versus State, granting relief on direct appeal based in part on judicial bias. They also quote Alexander versus State, reviewing a claim of judicial bias for plain error on direct appeal, despite failure to request recusal at trial. Review of the issue on post-conviction is procedurally barred. Right. Proposition 3, petitioner claims for the first time in his post-conviction proceeding that relief should be granted based on the state's intentional destruction or loss of the evidence. The only facts cited by petitioner about the loss of this evidence are found in the trial record. Petitioner provides no additional information to support the claim that the evidence was intentionally misplaced or destroyed in violation of due process. This claim could have been raised on direct appeal and is therefore waived. Proposition 3 is denied. So they deny Proposition 2 and Proposition 3.
Right. And that one that you just read, destruction of evidence. So that's another thing that's always common with the anti-death penalty ideologues. Mm-hmm. They destroyed evidence. You see that in an appeal. I just wanted to throw that in there. Mm-hmm. If anybody is listening.
But if it's a part of the trial record, then you're bringing it up too late now.
Right. Exactly.
You should have brought it up he should have brought it up in direct appeal.
Exactly.
If he brought it up in direct appeal, it might have worked, might not, because he had the ability to request cell phone records and he didn't. Just because he didn't have the physical cell phones doesn't mean. All right. Proposition 4, we find the claim could not have been raised on direct appeal and will review the claim here to determine whether the error supports a conclusion that the outcome of the trial would have been different. A violation of Anderson, which is regarding a question from the jury about life sentence, is an instructional error. We do not automatically reverse a case for instructional error, but rather determine whether the error resulted in a miscarriage of justice or constitutes a substantial violation of a constitutional or statutory right. Other factors support a conclusion that the outcome of the trial would not have been different. The jury in this case unanimously found the existence of 4 aggravating circumstances in 2 deliberate murders, including petitioner's conviction in a prior homicide. The jury unanimously found that the aggravating circumstances outweighed the mitigating evidence, some of which, especially petitioner's connection to his brother, was quite powerful. The jury unanimously rejected not only the hypothetical life sentences mentioned in its question to the district court, but also the available sentencing option of life imprisonment without the possibility of parole. Given this combination of circumstances, we are not persuaded that any error in the district court's failure to give an instruction on the 85% rule supports a conclusion that the outcome of the trial would have been different. Proposition 4 is denied. Proposition 5, having reviewed petitioner's individual claims of ineffective assistance of counsel, we find the factual basis for the claims identified above were ascertainable through the exercise of reasonable diligence and could have been raised in the direct appeal. Appellate counsel pursued several allegations of ineffective assistance of trial counsel on direct appeal and sought to supplement the appellate record with additional material supporting claims of trial counsel's ineffectiveness. On direct appeal, we carefully considered the arguments raised by appellate counsel according to the standard of effective assistance in Strickland versus Washington and concluded that ineffectiveness had not been shown. We are not persuaded. Yeah, sorry.
This real quick, this Strickland Washington, this is one that if people are actually reading appellate briefs, is this the one that Strickland commonly referred to when they're talking about ineffective?
Correct. Okay. And basically you have, it's two prongs with Strickland. I think you have to show that the conduct was not reasonable.
Right.
And also you have to prove actual prejudice.
Right.
So you can have a situation where, well, trial counsel's conduct was not reasonable because they didn't adequately prepare to cross-examine this state witness. But there was no prejudice because they did get, they did poke holes in that witness's testimony. They just didn't poke the same holes that post-conviction counsel believes that they could have. And this is actually one, kind of, it's like not discovering impeachment evidence that could have been used against the witness.
Right. So in some of the other cases you've covered, in these opinions, you hear a lot about the Strickland and the prongs. And so what I usually hear in the appellate decisions are that actually that their counsel was effective and the reason they made certain moves was actually part of their trial strategy.
Correct. And that is, yes, that is another factor where, and a lot of times what it is, it's basically, it's post-conviction counsel second guessing every decision made by trial counsel. And you'll have instances where trial counsel comes in and says, well, I didn't do this because, and it's there. That's a perfectly reasonable,
right.
Like I didn't, in a rape case, I didn't, tear into the victim because I could see from the look on the jurors' faces during direct examination that, they had a lot of sympathy for her. And if I attacked her, they were going to really hate my client.
Right.
Or the child victim or a child witness in a traumatic event. Right. And same, it's the same in the civil realm. You kind of have to look at how the jury is looking at the witness during direct to decide how hard you go after them on cross.
And here's a great example. Not even me, nobody at all disagreed with the fact that Richard Glossop's first trial, his attorney was an absolute idiot. And he had to write. I was totally okay with him getting a second trial because that guy, I don't know what his name was, Mr. Fornett or something.
Wayne Fornett.
Oh my. Listen, you definitely get it. You get a new trial. If that's the guy you started with, he didn't know what, that guy was terrible. And so understandably, he got a second trial.
All right. So Proposition 5 going on. We are not persuaded that appellate counsel's omission of the additional claims of ineffectiveness presented here was professionally unreasonable or objectively deficient according to prevailing professional norms. Considering these claims in light of the ineffectiveness claims and other issues raised on direct appeal, post-conviction counsel has not demonstrated a reasonable probability that the inclusion of these claims on direct appeal would have changed the outcome of the proceeding. The claims of ineffective appellate counsel are denied. The underlying claims of trial counsel's ineffectiveness are procedurally barred from consideration in a post-conviction proceeding. Petitioner states that he was never informed that Billy Coyle was married to Assistant District Attorney Heather Coyle, and that Billy Coyle never once informed Petitioner that his wife was an Assistant District Attorney involved in the prosecution of this case. Petitioner terms this an inherent conflict of interest that denied his right to effective assistance of counsel. And I'm actually quite surprised that the clown posse were not trotting this old chestnut out.
Yeah. Right.
Because it's such, a conflict of interest. Oh my God.
Yeah.
But then, when you look at the reality is that all of the facts shown here were readily ascertainable through the exercise of reasonable diligence at the time of direct appeal. The conflict of interest issue could have been raised and, if necessary, factually developed on direct appeal. The issue is therefore waived. Cognizant of the waiver, appellant claims ineffective assistance of appellate counsel and moves for an evidentiary hearing to further develop the conflict of interest claim. Beyond the mere allegation of the marital relationship, petitioner's application and supporting materials make no attempt to show that Heather Coyle's contact with the case prior to Billy Coyle's entry of appearance infected his subsequent representation with an actual conflict of interest. Beyond the factual allegation that Ms. Coyle signed a document filed in the case prior to trial, petitioner has not shown that her involvement continued at any time when her husband and father-in-law served as counsel for the petitioner. The docket and appearance sheets filed in this case fail to recite a single instance in which Ms. Coyle appeared on behalf of the state in pretrial hearings. Petitioner has not shown that appellate counsel's omission of this conflict of interest claim supports the conclusion that the outcome of the direct appeal would have been different. His submissions do not meet the criteria to remand this issue for an evidentiary hearing, and under Rule 9.7 D5. Post-conviction relief on this claim is therefore denied. Proposition 6, the prosecutor's remarks clearly could have been challenged on direct appeal. To the extent that some of these remarks were challenged on direct appeal, the issue itself is res judicata. Means we've already decided it. The failure to challenge other remarks results in waiver of those claims on collateral review. We have considered each instance of allegedly improper argument and conclude that petitioner has not shown any error rendering the trial process fundamentally unfair. And that cites Darden versus Wainwright, which is a U.S. Supreme Court case decided in 1986. Consequently, he fails to show that appellate counsel was ineffective in failing to bring these claims and related claims of trial counsel's ineffectiveness before the court on direct appeal. Finally, Proposition 7, we are not persuaded that the cumulative effect of any errors committed in the district court proceedings rendered the trial fundamentally unfair or produced an unreliable result. Appellant's Proposition 7 is therefore denied. After carefully reviewing petitioner's application for post-conviction relief and his request for discovery and evidentiary hearing, we conclude 1, there exists no controverted, previously unresolved factual issues material to the legality of petitioner's confinement. 2, petitioner could have previously raised his asserted grounds for post-conviction review. 3, the grounds for review which are properly presented, have no merit. And 4, the current post-conviction statutes warrant no relief. Petitioner's original application for post-conviction relief and related motions for discovery and evidentiary hearing are denied. So basically, that means Hancock presented everything, and the court found that his claims and his evidence supporting those claims did not meet the bar to grant him relief.
And relief means in these instances with post-conviction and death penalty, the relief means maybe time to develop a claim about something that you said.
It could mean a chance to go back to the court for an evidentiary hearing.
Right. But all of those things have to do with your counsel developing a claim about something that could then that lead to a logical explanation, and then you get, your case thrown out, or something new happens, or a new sentencing. And so these are appellate procedures where judges are looking down the road saying, we have tried to apply what you're saying and developed it ourselves, or looked at it a certain way, and we don't see at the end of the road that there's anything at the end of this logical road when we apply the law to grant any relief. Is that about right? Is that fair?
Yeah.
In layman's terms, non-legal.
In other words, he wasn't presenting anything that was merited going back to the district court for an evidentiary hearing.
Right.
And he hadn't presented anything that would merit having discovery.
Right.
And holding off on entering their opinion.
Right.
And in reality, in the end, his claims did not merit a new trial or a new sentencing or an alteration of his sentence in any way, shape, or form.
Yeah. I mean, those are important things that I mean, I didn't really understand a lot of this until you guys all ended up on my doorstep during Julius Jones. But I'm very grateful that because this is the stuff in the weeds that if people really looked at it and read it and took the time to do so, they would be just like Craig Blankenship, Andrea Blankenship's, I think, father-in-law at one time, who was murdered by Lawrence Anderson. And they would probably be more a lot like him, which I am, which is, are you willing to bet your family on this?
Yeah. Yeah. All right. So next we have some pro se actions filed by Phillip Hancock without the assistance of counsel. On May 16, 2011, he made a public records request to the Oklahoma City Police Department. He wanted photos from the homicide case taken prior to collection of the exhaust pipe claimed to be from Hancock's vehicle. He wanted evidence log entry for the tailpipe for any handling, testing, removal, return, or examination of the evidence. He wanted the evidence log pertaining to the 911 call made by Donald Jones, who was a neighbor of Bob Jett, on April 27, 2001. He wanted all requests and release of information on any person who had received the 911 call by transcript or audio recording. Basically, I think he was trying to determine what the prosecutor had and what his attorneys had gotten, and any other documentation relative to the request. Then on August 26, 2011, he sent another records request to the Oklahoma City Police Department. He was seeking the 2 cell phones listed on the evidence inventory log collected from the crime scene and cell phone records for April 27, 2001. And again, any other documentation relevant to the request. On October 13, 2011, he filed a petition for writ of mandamus. The case was Hancock versus City Chief versus I think Williams City, Chief of Police, Oklahoma City Police Department. Docket number was CV-2011-1784. And that basically was a petition for writ of mandamus, seeks a court to order a court or state agency to do some action.
Because he can't.
He can't. And he was seeking an order directing the respondent to respond to his public records requests, which he alleged contained exculpatory evidence. On April 27, 2012, an order of dismissal without prejudice was entered pursuant to Rule 9A because the plaintiff had failed to issue a summons or file a waiver within 90 days of the date of filing of the petition, or an alias summons within 30 days after return of a summons not served. So he basically didn't serve on the Oklahoma City Police Department. Then on May 14, 2012, Hancock filed against the chief medical examiner at the time another petition for writ of mandamus, CV-2012-605, seeking amendment of the incorrect marking of the gunshot wounds on the anatomical chart of James Vincent Lynch. And here he was trying to argue that some photos showed stippling or gunpowder residue.
Like close range.
Indicating close range
Yeah.
Discharge of a firearm. And he wanted the anatomical, or he wanted the anatomical charts, either the location or the stippling to be noted on the charts. Which, you're not a medical examiner, honey. And just because you think it looks like gunshot residue in a picture doesn't mean it was actually gunshot residue or stippling or what you want it to be, because it supports your story. Mm-hmm. And this is one of the things that is so crazy about true crime in the internet age. Mm-hmm. You have got people who don't have a scintilla of experience or education or training, who take a photo and say, this is what this photo shows.
Right.
And it's like, I'm the first person to admit it's a picture. This is what it may look like to me, but I don't know if that's stippling or if it's dirt.
If I tell you it's dirt, then I can say it's junk science.
Yeah, right, exactly. And there's so much, and that's the other funny thing too, is there's so much freaking junk science on the internet, mm-hmm. in the true crime realm.
Right.
On both sides.
But by God,
because people get so invested in their opinion.
Yep. But by God, you better let him get his DNA testing. You better let him use that junk science in case, it might actually be in his favor. Yeah. So
this one, Hancock actually did serve by certified mail, and it was received by the medical examiner's office on May 11th, 2012. Then he filed a second claim against the Oklahoma City Police Department, who was still being represented by Mr. City, on May 10th, 2012. So I actually have these out of order, sorry. That was assigned docket number CV-2012-1009, and it was another petition for writ of mandamus identical to the 2011 public records, seeking an order regarding the 2011 public record request. On August 1st, 2012, mm-hmm. a response, objection, and motion to dismiss of respondents to petitioner's writ of mandamus and brief in support was filed, saying that Hancock was not entitled to the production of any law enforcement records under the Oklahoma Records Act 51 OS section 24A.1 et sec, and that he had failed to state a claim under any other statute. And I don't remember whether this was in the city or the medical examiner. I think it was in the city one.
So
I should have indicated that.
Why is he? Explain why he's filing. You said these are pro se filings. These are ones why isn't there a representative? Why isn't there a counsel filing these for him?
It more likely than not was counsel didn't really think they had a leg to stand on.
Okay.
And it may have been something that Hancock just wanted to do. I don't know if Hancock was off the reservation, mm-hmm. and doing something his counsel had said, no, let's not do this.
Right.
Because you have to be careful, because if you get these records in 2012, right. and then your attorneys try and use them in 2016, mm-hmm. you're outside the 90 days.
Oh, okay.
So you have to be very careful, because if your counsel brings this stuff up or develops something from this, and then they say, well, yeah, but Hancock got these records in 2012, he should have filed within 90 days, you're screwed. Right. But or whether his counsel was kind of like, well, that might be a good idea. Let's go see what happens. He didn't really pursue it too diligently.
But like the phones, I wondered at first, well, why would he want the cell phones? Well, apparently, according to this person whose last name is Tarp, Mr. Jett got a phone call and in the other room. And then
no, what Hancock was trying to prove was that Hancock claimed that he got a call from somebody that told him that Robert Jett wanted him to come pick up Catherine Quick that night.
Yes.
And so what he wanted Jett's cell phones to prove that Jett called this person and instructed him to get Hancock over there.
Right.
He was trying to claim he was set up.
Yes. Right.
And now, he didn't need Jett's phone. He should have just had his phone to prove that he got the call that night. But my belief is that there was never any call telling him to go over there. He was going over there looking for her, thinking she would still be there. And she wasn't.
And he was going over there and just simply entering the property. I don't know how you even get to self-defense once you enter a property without asking permission. Yeah.
Right. Well, no, he always heard some phantom. I mean, Robert Jett must have had a ghost living in his house.
Yeah.
Because not only did the ghost tell Hancock he could enter the morning of the 25th or 26th, but the ghost told him to enter again the evening of the 26th.
Right.
And the ghost told him he could open a new pack of cigarettes and take himself a cigarette out too.
Right.
So, Hancock filed a motion for directed verdict in the ME case on August 9th, 2012, because the ME had not responded to the summons. Then he filed a motion for request for assigned counsel in the city case on August 14th, 2012. He also filed a writ of habeas corpus ad testificandum on August 20th, 2012, probably to get himself out of prison to come down to Oklahoma City and testify in a court hearing. The respondents filed an objection to petitioner's request for assigned counsel and for issue of writ of habeas corpus ad testificandum on August 28, 2012. Petitioner's motion for request for assigned counsel fails to comply with the rules for the district court and state law, and that the writ of habeas corpus should be stricken. An order denying the request for assignment of counsel was entered on August 30th, 2012. Petitioner's motion fails to list any authority for his motion, and said motion should be denied without hearing pursuant to District Court Rule 4D. It is so therefore ordered by the court that petitioner's motion for request for assigned counsel is denied. And then an order sustaining the motion to dismiss was also entered on August 30th, 2012. Petitioners failed to file a response to respondent's response, objection, and motion to dismiss. And said motion is deemed confessed pursuant to District Court Rule 4E. And this case should be dismissed without prejudice, meaning he can refile it. It is so therefore ordered by the court that respondent's motion to dismiss is sustained and the case is dismissed without prejudice. Then there was a notice of disposition docket filed on October 20th, 2015, basically just dismissing the case without prejudice by the court unless counsel appears and showed good cause why the case should be allowed to remain on the docket. And that was in the ME case. And then there was an order of dismissal for failure to prosecute on December 3rd, 2015, because no one appeared.
Right.
So that was the end of the pro se actions. So now Hancock goes to federal district court. And I'm actually, since federal habeas is kind of a combination of claims made on direct appeal and post-conviction, I'm not going to go into the grounds of Hancock's federal claims because it's we're getting into the weeds a little bit on the information, and I don't want to belabor the points. Hancock was represented by David B. Autry and Lanita Henriksen, and the state was represented by Jennifer L. Crabb. The jurisdiction, the venue was U.S. District Court, Western District of Oklahoma. The case was assigned docket number 5:08-CV00327, and it was the Honorable Stephen P. How do you pronounce his last name? I always pronounce it Frio because I'm from Louisiana. What is Stephen's last name? How is the correct pronunciation for an Oklahoman?
Friot. Is that what this point?
Yeah.
I don't know that either. I have just said Friot as well.
Okay. That's all right.
I don't. I didn't know how to pronounce amicus in amicus brief. I still don't even know if I pronounce it right. I've heard
you actually pronouncing it correctly. And the plural is amici.
Amici. Okay.
Mm-hmm.
I didn't. Yeah. I think I just figured out how to pronounce Napu. Is it Napu? Just from listening.
I think it's kind of. I think different people pronounce it different ways. I've always said Napu.
Oh, okay. Well, seeing there were attorneys.
But I think they were saying Napu at the Supreme Court.
Yeah. So it's kind of like in theology. Is it Augustine? Do you say Augustine or Augustine? So
yeah. All right. So March 28, 2008, Hancock filed a motion to appoint counsel and a motion to proceed in form of pauperis, which means he would proceed without paying any fees. An order was entered on March 28, 2008, referring the case to Magistrate Judge Gary M. Purcell. Another order was entered appointing Autry on April 2nd, 2008. A case management conference was set on April 3rd, 2008, which would be to be held on May 6th, 2008 at 10 a.m. On May 6th, IFP in form of pauperis was denied, which just means that now Hancock has to start paying the filing fees. Case management order was entered on May 6, 2008. After the conference, the petition was due on November 6, 2008. A response was due 42 days after the petition was filed, and Hancock could reply 30 days after the response, and the state was ordered to provide the state court record. Also, the case was transferred back to Judge Frio from Magistrate Purcell. Motion to correct the motion to appoint counsel was filed on August 22nd, 2008 by Hancock. And on August 22nd, an order granting that motion was entered, correcting the motion to appoint Lanita Hendrickson. Order was entered on November 5th, 2008, granting an extension of time to file petition to January 15th, 2009. A second order granting a second extension of time to February 3rd, 2009 was entered on February 2nd. The petition was filed on February 3rd, 2009. And like I said, it's a melange of the direct appeal and state post-conviction allegations. So I'm not going to go into the almost 3 pages, almost 4 pages of grounds
yet, or 15 or 16. We haven't even gotten to 2021 when they allegedly have brand new evidence and all that stuff.
Right.
Yeah.
So,
but these appeals are mainly he's taking it like this little run of filings seem to be focused on his due process rights or constitutional
correct
rights. Okay,
correct. And this is alleging constitutional errors, and they can allege, they're alleging ineffective assistance of trial and direct appellate counsel and state post-conviction counsel.
Yeah.
And there are some different grounds, like they allege failure to impeach trial witnesses that weren't alleged in the state post-conviction. But again, it's just kind of throwing everything at the wall to see what sticks. It's called the shotgun defense, and including cumulative error. So, and basically what cumulative error is even if the errors aren't enough on their own, to warrant relief. The effect of all the errors is so much that it denied a fair trial.
And just for the record, this guy's got way more they threw on the wall than Julius Jones. Right? I mean, I've never seen so much stuff. This is shotgun effect is a great way to put it.
So, or the spaghetti defense, which is throw it at the wall and see what sticks.
Yeah. Wow.
And they threw a couple pots of spaghetti at that wall.
Yeah.
So, on March 16, 2009, the state was granted an extension of time to file its response, which was due March 26, 2009. On March 18th, Hancock sought an evidentiary hearing. An order was entered on March 23rd, granting a second extension of time to April 2nd, 2009 for the state to file its response. It filed its answer on April 2nd, 2009, and response in opposition to motion for evidentiary hearing. An EOT was granted to file a reply to the state's answer and opposition to the evidentiary hearing, first to June 3rd, and then a second order granted us an additional extension to June 13th. Hancock filed his replies on June 15, 2009. The state court record was lodged or filed on August 12th, 2009. And on September 7th, 2012, 2 years and 1 month later, the magistrate, the federal court judge issued his opinion. And it was a memorandum opinion, and it was 118.
Hello?
I'm still here.
Okay. It was 118 what?
Pages.
Yeah. So listen, the system is working. You're getting your due process, right?
Mm-hmm.
Okay.
Exactly.
Yeah.
So the judge found that petitioners presented 16 grounds for relief. Document 27. Respondent has responded to the petition, and petitioner has replied. Documents 37 and 43. In addition to his petition, petitioner also filed a motion for an evidentiary hearing, to which a response and reply have also been filed. Documents 34, 38, and 43. The state court record has been provided. Document 45. After a thorough review of the entire state court record, the pleadings filed herein, and the applicable law, the court finds that, for the reasons set forth below, petitioner is not entitled to his requested relief. Now, next comes 118 pages basically denying each ground for relief, either denying because they lack merit or denying because they were procedurally barred. And then the court said, in closing, on the issue of ineffective assistance of counsel, especially but not exclusively, the court cannot but note that effective advocacy on habeas review, no less than on direct review, requires the exercise of sound professional judgment as to the issues to raise and argue. The exercise of that judgment is at least as important in capital habeas cases as in other cases. This is the winnowing as discussed in Smith versus Murray, Supreme Court case decided in 1986, that is a hallmark of effective advocacy. On the effective assistance claims, the court sees very little to indicate that sound professional judgment was brought to bear by petitioner's present counsel in deciding what criticisms to level at petitioner's trial counsel. Although the court is at pains to emphasize that all of petitioner's claims of constitutionally deficient trial and appellate counsel have been carefully considered, it remains true that the important task of focusing intently on the claims that may have some arguable merit is not made easier when those arguably meritorious claims are served up in the same pot with what can only be called trivia.
Wow.
And in a footnote, the court said this case is a good example of the reasons for which the court has established page limitations in capital habeas cases. See General Order 10-1. The limits set forth in the general order, although generous, will have the effect of requiring or at least encouraging some winnowing.
Yeah.
And then, because no further development of the record is necessary, petitioner's request for an evidentiary hearing is denied. A judgment was entered on the same date, basically denying the writ of habeas corpus and entering in favor of respondent and against petitioner. A certificate of appealability was issued on September 7th, 2012, because in federal court under EDPA, you can't appeal the denial of habeas corpus in the absence of a certificate of appealability, either issued by the district court or by the court of appeal.
Okay. I think you talked about this in a previous episode.
So, and in the certificate of appealability, having thoroughly reviewed each claim raised by petitioner, the court finds that a COA should issue only on one ground, ground 4. Ground 4 concerns the omission of petitioner's prior manslaughter conviction in the guilt stage. Although petitioner has been denied relief on this claim in light of EDPA deference and a finding by this court that the omission of such evidence did not render petitioner's trial fundamentally unfair, the court acknowledges that resolution of this claim could stir debate among reasonable jurists. The claim alleges a deprivation of due process and is deserving of additional consideration. For the reasons set forth in the memorandum of opinion, petitioner's remaining claims do not merit the same consideration. Therefore, the court grants the COA on petitioner's ground 4 and denies the COA on petitioner's remaining grounds. Hancock filed his notice of appeal on October 4th, 2012. That was appealed to the 10th Circuit Court of Appeal. The docket number was 12-6255, and the panel was Lucero, Matheson, and Bacharach. I wonder if he's any relation to Bert.
I don't know.
His counsel were David Autry, Madeline Cohen, and Lenita Henriksen, and the state was again represented by Jennifer Crabb. October 25th, 2012, a case management conference was set for November 27th, 2012 at 9:30 a.m. A motion to appoint was filed on October 29th, 2012, seeking to appoint Madeline Cohen. An order was entered granting that motion on, November 7th, 2012, and resetting the conference for January 22nd, 2013. A motion to expand COA was filed on December 12th, 2012 by Hancock, and an amended motion was filed on December 19th. Now, I'm not entirely sure what the motions to expand, but it appears that he was trying to raise issues regarding whether the jury was misled by unwarranted instructions on self-defense and allowing the prosecutor to make misleading arguments in closing. Trial counsel was constitutionally ineffective for failing to request a jury instruction on the lesser included offense of manslaughter while resisting a criminal attempt. Cumulative error deprived Hancock of a fair trial and sentencing. Was the evidence insufficient for the conviction on first-degree murder? Was trial counsel ineffective for failing to effectively impeach the state's witness, Ms. Shawn Tarp, with her previous statements? And was appellate counsel ineffective for failing to claim ineffective assistance of trial counsel? Did the state district court deny Mr. Hancock the right to present a defense by excluding evidence that would have supported a finding of self-defense, which I believe was a statement to another witness? And was the evidence insufficient to support the aggravating circumstance of murder that was especially heinous, atrocious, or cruel?
See, here I'm hearing the kind of questions that I feel like I'm listening to Amanda Bass. These are the kind of questions that she seemed to raise, only they got weirder and weirder. But this is a level of litigation that's not the same as just being a defense attorney.
Well, I think that some of these federal public defenders are I think they have a handbook.
Right.
And because you see a lot of these, and sometimes it's blanket, and sometimes it's nitpicky.
Right.
So, yeah, but these are what he was trying to expand it to. And this is based on the argument that reasonable jurists could debate the merits of these issues. An order was entered on December 20th granting the amended motion to expand COA filed on 12/19 and replacing the motion to expand filed on 12/12. A case management order was issued on January 22nd, 2013. Appellate brief was due on November 1st, 2013. Appellee brief due January 30th, 2014, and a reply brief was due on March 17th, 2014. So,
Jeez.
I mean, he's getting 11 months to do his own brief.
Yeah.
Motion to further expand COA was filed on January 30th, 2013. An order was entered on September 13th, 2013, extending the briefing deadlines by 30 days, although the state really didn't get 30 days.
Right. I can see that.
Now, that may have been an error on the docket because they don't issue a paper order for that. They just do a docket entry.
Mm-hmm.
So the person making that docket entry may have their brief may have been due at the end of February rather than the end of January because they literally got 1 day.
Wow.
Well, Hancock got 30 days.
Yeah.
Appellant's brief was filed on December 2nd, 2013. The state filed its brief on January 13th, 2014, which means they filed before their brief was even due. And then the reply brief was filed on April 16th, 2014. An order was entered granting in part the motion to expand COA on May 27th, 2014. A supplemental briefing schedule was issued for supplemental briefs due on October 22nd for Hancock, December 8th for the state, and then December 29th for Hancock's reply. He filed his supplemental brief on the 20th. The state filed theirs on the 5th of December, and he filed his reply on December 29th. Oral argument was held on March 17th, 2014. On August 18th, 2015, again, more than a year later, the panel issued its opinion. On issue number 1, they concluded that Mr. Hancock has not met his burden because the OCCA's opinion can reasonably be read as factually accurate. As a result, Mr. Hancock has not shown that the OCCA unreasonably determined the facts, preventing us from deciding the merits of the due process claim. Issue number 2, we conclude that the OCCA reasonably applied Supreme Court precedents and determined the facts. As a result, we cannot reach the merits of the claim. Issue 3, we conclude the OCCA did not act unreasonably, for fair-minded jurists could conclude that defense counsel's theory of manslaughter fit the evidence just as well as manslaughter while resisting a criminal intent. Thus, we cannot reach the merits of the ineffectiveness claim. Issue number 4, we conclude that Mr. Hancock is not entitled to habeas relief based on cumulative error. This protection is triggered only when there are 2 or more constitutional violations. There were not 2 or more constitutional violations in this case. Motion to expand the COA, we deny the motion, the certificate of appealability to expand the certificate of appealability on these issues. In summary, we affirm the district court's denial of habeas relief and deny Mr. Hancock's motion to expand the certificate of appealability. Judge Lucero issued a dissent. Chief Judge Lucero, pardon me, I concur in all but section 4B of the majority opinion in which my esteemed colleagues hold that Hancock has failed to prove that the OCCA's decision was based on an unreasonable determination of the facts. And so holding, my colleagues failed to credit Hancock's proof that the OCCA concluded that the trial court admitted the evidence under Oklahoma Statute Title 12, Section 2609B, when in fact the trial court expressly excluded the evidence under that section. My colleagues acknowledged that the OCCA did not tell us what it thought the district court had relied on to admit the evidence, but they mistakenly read ambiguity into this silence. They failed to recognize that the only logically consistent reading of the OCCA decision is that it is improperly predicated on a misreading of the trial court decision. I would reverse. And that was I'm not quite sure what that was. I'm sorry. Anyway, he didn't agree.
He didn't agree, and it
doesn't really mean anything. I mean,
I'm right. I mean, look, when they take votes at the Pardon and Parole Board, the 3-2,
yeah,
the like just an offshoot of this. You're always going to get one person, sometimes, or city council votes that they meet before actual, you see them in their public meeting. It's like there's always going to be somebody's going to offer the consolation opinion or vote. So at least you don't feel like you got your ass kicked into the dirt entirely. But I don't even know the point of going into this dissent or why he put it there, but clearly I'm not going to question, his, that he would reverse, but it's there, and I'm just not sure why it's there, because once you put it there like that, if it doesn't change the outcome, all you're doing is giving fodder for somebody else later down the road.
Right. And, I'm not quite sure. This dealt with, I think, the admission of the prior conviction.
During the trial.
During the trial, yeah.
Because his prior record would have come up in the sentencing phase, right? Correct.
But it could have been entirely left out. I think what happened was because he was testifying, they went ahead and they got the first-degree manslaughter on the table.
Yeah.
And dealt with it.
They dropped the ball.
But what happened was that benefited the state because it said, see, he's done this before and claimed he was in fear for his life.
Right.
When, as I recall, he shot a shotgun into a crowd and not only killed one person, but wounded 2 others. And he was on drugs. He was high. So, he didn't have the best judgment when he was high.
Oh.
And killing people was, one of those failures of judgment for him.
Yeah.
Anyway, so the appellate court entered its judgment on August 18th, 2015. Hancock filed a petition for rehearing on October 2nd. 2015, a response was filed by the state on October 14th. An order denying petition for rehearing was entered on December 11th, 2015. The mandate issued on December 15th. Hancock filed an application for extension of time on February 16th, 2016. He was granted an extension of time to May 2nd, 2016 to file his petition, which was filed under docket number 15-9190. And that was filed on May 2nd, 2016. A conference was held on September 26, 2016. And then on October 3rd, 2016, the writ was denied. Hancock filed an application for authorization to file a second or successive petition for writ of habeas corpus in the 10th Circuit Court of Appeals. His counsel was Madeline Cohen, and that was filed under docket number 17-6013. That was on January 18, 2017. He sought authorization to file a subsequent application based on Hurst, which was a Florida case decided by the U.S. Supreme Court, requiring the weighing determination in mitigation versus versus aggravation beyond a reasonable doubt. And that was a challenge to Florida's death penalty scheme. And they were trying to argue that that applied retroactively. So he filed his second petition claiming that Hearst renders Oklahoma's capital sentencing statute and Mr. Hancock's death sentence unconstitutional. Its retroactive change in the law entitles Mr. Hancock to sentencing relief, and the error in Mr. Hancock's capital sentencing was structural and not subject to harmless error review. He filed a motion to appoint counsel, which is basically just making sure that Cohen is appointed and can be compensated under the federal scheme for indigent defense. A response was filed to the application by the state on January 20th, 2017. An order was entered granting the motion to appoint on February 10th. And also on February 10th, the 10th Circuit dismissed the request for successive authorization, holding that the Supreme Court is the only entity that can make a new rule retroactive. That's under Tyler versus Kane, decided in 2001. And as we held in Ray Jones, a slip opinion at 4, the Supreme Court has not made its decision in Hearst retroactively applicable to cases on collateral review. Movement, therefore, does not meet the requirements of 2244B2A. The motion for authorization is denied. This denial of authorization shall not be appealable and shall not be the subject of a petition for rehearing or writ of certiorari.
And that is 16 years after. So this is the Jett and the Lynch family have now 16 years have gone by.
Yeah.
Listen, there's nothing flashy about going through all of this, right? It doesn't read like a tag on the headline news that most people like to click real quick. And there's absolutely no way that McDougal and the Cowboy Posse have even gotten into this part of the weeds. They say the system is broken. No, if you read these things, that's why you read these things, you can clearly see that it's impossible to say that a system is broken when somebody has so many opportunities to sort of litigate so many different things from so many different angles. It's like
the problem is that in their little pea brains, and I hope they're listening when I say they have pea brains, and that's PEA, little bitty tiny round things that are green. They are under the impression that due process is success. If you go to court and you don't succeed, you didn't get due process. And so that's why. And they distort the process by holding out that is so.
Like, it's like you can't even look at this and read it and go through it in this way and say, well, how is it that they didn't determine that he was acting in self-defense? Because that's essentially where they go right before his execution. How could you not understand that we have a right to defend ourselves? I mean, what do you...
Well, but they played the... they portrayed it as self-defense, but the reality is what Phillip Hancock says happened didn't happen.
Right.
He was not attacked by Jett and Lynch.
Right.
There was no effort to put him into that cage.
Right. And really, the sooner that people in the national media and even our Oklahoma media, the sooner that somebody actually begins to report these kinds of things, right, instead of just regurgitating things like Bob Macy was the DA when he wasn't, then the sooner people will become more in the know about this. But I don't think that's what they want to happen. And that's a big problem for me because it's a problem for victims and families.
So I'm right there. I know it frustrates me to no end.
Yeah.
So this is 20. We get into 21. We're now coming into 2021, and they know that Oklahoma is about to resume executions
Yeah.
because the Glossop challenge to the new procedure is on its final legs.
Mm-hmm.
And so they come up with a successive state claim. Counsels Lanita Henriksen and Hunter Labowitz, who's with the federal defenders for the Eastern District of Pennsylvania. So the anti-death penalty folks are getting so desperate that they're having to bring people from Pennsylvania because they ain't got nothing to do because there's no death row, virtually no death row anymore in Pennsylvania. So now they're bringing them down to come to Oklahoma and Texas. And so this is, really funny. Oklahoma Court of Criminal Appeals is the jurisdiction, venue, docket numbers PCD-2021-616. Now, they've obtained a declaration from Catherine Quick, who was Phillip Hancock's ex-girlfriend.
Mm-hmm.
Basically, she met Phillip Hancock. They started living together. He was still married, so he ended up divorced. They were doing drugs. She started shooting up drugs. He didn't like it. And she claimed, and I'm going to go over, there were a lot of claims in the affidavit, but basically she claimed that she offered Bob Jett a few $100s to get Phillip Hancock off her back.
Right.
Now, this is something that never came up during the original investigation. And I don't think they ever found any evidence that suggested that that was what happened.
No, and there is a blazingly opposite opinion about her declaration. And this is the declaration that the Cowboy Posse and the media came out with in 2023 as we have brand new evidence.
Correct.
This is actually not brand new. It was in 2021.
Correct.
So people, if they were really paying attention, they would see this isn't anything new.
Yeah. And so he filed a second application on June 18, 2021, claiming that her admission that she had Mr. Hancock set up requires his convictions and death sentence to be vacated in the interest of justice and based on Mr. Hancock's innocence. On May 11th, 2023, so 2 years, this was in consideration, a little bit under 2 years. An opinion denying second application for capital post-conviction relief and related motions was filed by the Court of Criminal Appeals.
This is their opinion about her little declaration.
Yes.
I wonder if the Cowboy Posse, when they announced their new evidence thing, knew that this had even come out in the same year.
I think they knew that it didn't come out, that it had come out, but I don't think they cared, and they don't respect the Court of Criminal Appeals. So, they want to make the Court of Criminal Appeals look like they're doing something wrong.
Because it said that it doesn't even involve a record. It's like it doesn't even involve a legal basis or anything. She wasn't even there. She didn't see what happened.
Yeah.
There's nothing.
And, the credibility, and this is one of their statements. Good reasons exist for not taking Kathy Quick's affidavit at face value. She admits her deep sympathy for petitioner and regret for her role in the events that transpired. She expresses sorrow for petitioner's situation and feels obligated to help him by coming forward after 2 decades. She does not want to see him suffer the death penalty and seems to think him free from fault in the killings of Jett and Lynch, which she is hardly in a position to know. The credibility of Quick's statement is diminished considerably by her current motivation and bias, the opportunity for recent fabrication, and the doubtful accuracy of her memory and perception when she was chronically abusing methamphetamine 2 decades ago.
Yeah.
And there are some other strong statements from our review. The verdicts and sentences are best explained by evidence that petitioner suddenly disarmed Bob Jett and shot him with his own pistol when Jett was no longer an imminent threat to him. then turned and fatally shot James Lynch, an obese, physically diminished, if not disabled, and unarmed man who posed little or no threat to him at any time.
Mm-hmm.
Bob Jett fled his own house knowing he'd been shot. Petitioner found him lying wounded in the backyard. As Jett pleaded either for help or mercy, Petitioner told Jett he was going to die and shot him twice more.
Mm-hmm.
So I'm not going to go into the reasons for denying. Those are, I think, those are the main. Those are the main things. I know we're at 2 hours, Jen. Are you pressed for time, or do you want to go ahead and get through the rest of this?
Well, are you talking
in an somewhat abbreviated fashion?
Well, I mean, are you talking about the whole he wants to get DNA testing?
I'm not going to go into the specifics or the weeds, but he did want to get DNA testing.
Right.
So he did want to try and get DNA testing because he alleged that DNA testing would support his story. The court found that was not the case and denied his initial request. He appealed, and the appeals court sent it back for a hearing. So I'm going to skip a bunch of things. They sent it back for a hearing. There was also a declaration from the jury foreperson, which was quite amusing because the jury foreperson says they did not disbelieve Hancock and felt he was in fear for his life and acted in self-defense, but they felt he flipped to an aggressor when he headed to the backyard.
Yeah.
So, they get a juror to come in, but they didn't get all 12 jurors.
No.
I would be impressed if they got all 12 jurors.
Right. And really, exactly. And this is kind of like the Julius Jones case. And all of these cases, once you get closer to the execution date, you start seeing we have brand new evidence, or we have a juror now who has has doubts about the decision. And it's typically not like they would have changed their mind. It's typically, well, I would have liked to have heard this. I would have liked to have heard that. Sure.
Yeah. And the reality is that jurors changing their minds has zero impact.
Right.
And in most states, you can't even bring that in. I mean, the courts do not give that any weight whatsoever. Because, of course, the juror is going to change his mind if you say we've proven him innocent. With this, that, and the other thing, even though that doesn't really prove him innocent.
Right. But a juror having second thoughts, which I'm sure that jurors, I'm sure they waver back and forth sometimes. At this juncture, you're at a level of post-conviction litigation where you've got to establish you're factually innocent.
Yeah.
Or you're getting the juice.
Right.
I don't mean to sound so cold-blooded, but you know what? It is cold-blooded because you've put the victims' families through a lot.
Yeah.
Multiply the number of years times 365. Yeah. I don't care if he dealt drugs or he dealt dope. It doesn't matter. I mean, you went over there and you killed them both. One who was disabled and obese, and the other guy in his own home, fleeing his own home.
Mm-hmm.
Yeah, shot the kill shots in the backyard. I mean, that's pretty heinous and cruel. And then now you add all of these years onto it. And I forget where I was going with that. Other than this is where the media, what is his name? A guy who was a forensic scientist, his last name is Collins. I think you might know the article. I know Roberta Glasswood. He came out with something back in the 2000 teens or maybe even earlier about the defense side of death penalty cases. The person who's set to be executed, the anti-death penalty ideologues, they rely upon the passage of time.
Mm-hmm.
10 years, 15 years, 20 years, so that then they can manipulate the media
right
to their story. And that's what I think that the Cowboy Posse was doing here.
Yeah.
Just like
That's what they do with glossip too. And then they say, well, if you're so sure, then well, what's the harm in a new trial? Well, because probably half the witnesses from that trial are no longer with us on this plane of existence. We
right,
need a Ouija board
right.
for
Well,
all those witnesses to testify.
for
So
in the glossip case, there's only one that's still alive.
yeah. So anyway, all right, let's go through. So the DNA request was remanded back to the trial court for a hearing, which was held on August 10th, 2022. At this point, Hancock had been set in the second phase of executions. Hancock sought an additional hearing date, which was denied. He wanted to bring in a forensic medical examiner to a forensic pathologist to say there was stippling on James Lynch. The court issued its finding of fact and conclusions of law, which basically found that Hancock was not entitled to DNA testing. And again, I mean, the findings of fact and conclusions of law in both of these DNA claim, they really lay out the facts of the case.
Mm-hmm.
But anyway, the request for testing was denied after the hearing. And basically, the conclusions of law were that petitioner has not met his burden of demonstrating that he's entitled to post-conviction DNA testing. He's not shown each of the 5 criteria necessary to permit an order for post-conviction DNA testing. Specifically, petitioner has not established a reasonable probability that he would not have been convicted if favorable results had been obtained through DNA testing at the time of the original prosecution. And number 4, even if favorable DNA test results were recovered from the subject items, the evidence in this case simply would not permit a different result at the time of the original prosecution. Yeah. Hancock appealed again to the Court of Criminal Appeals, and he was represented by that point by Jessica Tsang with the Eastern District of Pennsylvania's Federal Community Defender Office. And the record went back up, and on December 28th, he filed his appellant brief. On May 11th, 2023, the Court of Criminal Appeals entered a summary opinion reviewing for abuse of the trial court's discretion, which is the standard in this type of appeal, and they found no abuse of discretion in the denial of testing or the exclusion of medical examiner testimony regarding the presence of gunshot residue on a wound on James Lynch's hand. And so they affirmed the denial of the motion for post-conviction DNA testing. That mandate was issued on May 11, 2023. Then Hancock filed a federal civil rights claim arising from the DOC's confiscation of digital music downloads purchased by inmates from the DOC. Yeah. That was recommended to be dismissed by the court, by the magistrate. An objection to the report and recommendation was filed on February 10th, 2023, and that's as far as it went. Yeah. In 2023, his attorneys filed a civil rights claim based on the denial of DNA testing, alleging that the Oklahoma statute was unconstitutional and seeking a declaratory judgment of that to that effect. The process went through, and then finally on October 27, 2023, the court concludes plaintiff does not have standing to bring this challenge. Here, plaintiff's alleged injury relating to the preclusion of testing to challenge his death sentence is hypothetical. Plaintiff requested DNA testing to demonstrate that he acted in self-defense and is innocent of first-degree murder. Plaintiff was denied testing under the Post-Conviction DNA Act because the state courts did not find a reasonable probability that he would not have been convicted of murder in the first degree if favorable DNA results had been obtained at time of the original prosecution. He had also sought an injunction, and that was denied as well. There was a motion to dismiss and brief in support filed on October 30th, 2023, and Hancock filed a response on November 3rd, 2023, And that is as far as that challenge went. Nothing happened. They didn't try and stay his execution or anything like that in connection with that. And now we come to Hancock's execution. He was represented at that time by Timothy Kane, Jessica Sang, Sean Nolan, Megan LaFrancois, Hunter Leibovitz, all of the Federal Community Defender's Office of the Eastern District of Pennsylvania. The order setting execution date had been entered in July of 2022. An order confirming phase 2 execution dates was entered on January 9th, 2023. The Attorney General requested and the court granted on January 24th, 2023, an extension of execution dates. And so that was when Hancock's execution date was reset from May 4th, 2023 to November 30th, 2023.
Right.
On November 3rd, 2023, John W. Coyle III, one of his attorneys, filed a declaration claiming basically he was drunk and on drugs during the entirety of his representation, and Merle Gile was also drinking, so he had his own problems. That ignores the other 3 attorneys that Hancock had at that time.
Yeah.
And he tried to raise a bunch of issues, including apparently Tarp was so afraid to testify that she sought help from the DA to change her identity. And he tries to allege that she was afraid of bikers, that apparently trying to say, well, she wasn't telling the truth about what really happened because bikers were probably, threatening her to get Phil put on death row. But, that's just speculation. A petition for clemency was filed on October 19th, 2023 on behalf of Hancock, and that's when the Clown Posse had their press conference presenting the facts in a way that supports Hancock's self-defense claims without giving the AG or anyone supporting Hancock's conviction an opportunity to present a theory of the case or any facts that contradict Hancock's claims. This was another opportunity for them to criticize the death penalty in Oklahoma, falsely claiming that they support it, while undermining the decisions of every court that has examined Hancock's claims and found them insufficient to undermine confidence in his conviction or sentence. Clemency hearing was held on November 8, 2023. Clemency was recommended 3-2. On November 30th, 2023 at 9:10 a.m., there was a request for delay of Hancock's execution. Some reports say it was his attorneys, and some say it was the governor, who was still considering the recommendation for clemency.
I was there, and nobody ever could get any answer from the side about what the delay was, whether it was anything significant or not.
And then at 10:10 a.m., the governor made his decision denying the request for clemency, and the process of Hancock's execution began. He was taken to the death chamber. He was hooked up to the IVs, etc. Mm-hmm. You were outside now because you were outside throughout the whole process while you were waiting.
Correct.
So why don't you just give us your impressions and what you saw and heard during that time?
Well, I went there with the soul, and my intent was to be a presence for the victim's family, right? And I also was there, like the Cowboy Posse, to be interviewed by the Christian Science Monitor, who did a whole issue on Oklahoma's death penalty. And so it was myself and the Cowboy Posse, short of Mr. McDougal. So it was Justin Humphreys, Justin Jackson, another guy, Blake Stevens, I think. And then the only other people that were there were the Christian Science Monitor, a documentary guy from New York, and some people from Tulsa that brought about 12 students from a Catholic high school down to Big Mac right outside where they let you stand during the execution, which I thought was extremely inappropriate. But at that time, the Christian Science Monitor guy was going back and forth and asking us all different questions. There was the hoopla about what's the delay for, and Justin, the two Justins of the Cowboy Posse, tried to make tried to make a big deal out of it. They tried to make it real sensational. And the kids were praying and crying. Some of them were crying really bad, like, why are they going to kill him? And they held hands and said a prayer and sung Amazing Grace. And incidentally, I stood right there with him. I wasn't happy. No, this is not a happy affair. Mm-hmm. I just had a different view of what was happening. In my view, Mr. Hancock was about to meet his maker, and that was that, and justice would be finally adjudicated. In their view, he was being wrongfully put to death by a broken system. That was, that's the ideology there. I did have conversations with Mr. Humphreys and actually found him the most amenable to talk to about this. And I was very confrontational at times. But it was also raining, and when they finally said the execution is going to move forward, that's when the Cowboy Posse really amped up the attention from the people that were, I didn't see any other media there, like local. Mm-hmm. That's when they really amped up getting the attention of the Christian Science Monitor. And so there were times when they would say, why are you here? And I'd say, I'm here for the victims' families. And they would say, well, but why are you here? It's like they didn't know what I meant when I said that. So mm-hmm. It occurred to me that they could care less why I was there. And that was a good thing, because when they began, when we knew it had started, and so the media was all over the Justins, that's when I took my few minutes to quietly walk over under a beautiful tree. And I had a couple crosses, and I had a note to the Lynch family and the Jett family and the murder victims. And I said, this is over. It's time to be at peace now. Mm. And it's over. And I dug a little hole and I buried him right there. And nobody saw it. And that's what I meant. That's what I hoped would happen. And that was okay. And they didn't, because it was raining and I had a big umbrella. But that's all that was really going on. And boy, once it was over and he was declared dead, the Cowboy Posse was out of there. Mm-hmm. They're done. They weren't really, I don't know, it's hard to understand what they were really there for, other than just the totality of what they were trying to do with Richard Glossop or the death penalty in general. I don't think that Justin Jackson liked me at all, because, there was a point where I turned my phone on to record and I pointed it down just so you could just see my shoes. And, mm-hmm. and I was, I was very confrontational in the facts of this case and the Glossop case with him. And he just looked at me and gave me the F you look side eye, and he walked away. He didn't want to talk to me at all. Mr. Humphrey stayed and talked to me about it, and I don't know that Mr. Humphrey actually was the only person that I actually had a reasonable conversation with, because I don't know that he ever, I know that he stressed the self-defense. I know that the media sold that whole self-defense thing. And the media kept saying Phil Hancock who was convicted during the, Bob Macy era, when Bob Macy wasn't even the DA anymore.
Right.
But Mr. Humphrey just kept saying, but what if the system is wrong? Or what if one thing goes wrong and we've executed an innocent person? And so, for him to at least be honest to some degree about what if we have this wrong, that's fair to say, boy, I sure hope we don't get this wrong. And that's not a case by case. I think he was referring to the totality of it. But the others there were for the dog and pony show, so they could make a reference back to Richard Glossop.
But, that's kind of a straw man.
Exactly.
Because in cases, for example, they're always talking about how many people have been exonerated in Oklahoma. Well, guess what? That means the system works.
Right. And some of them aren't true exonerations of factual innocence. Some of them are, you just got let out because the system worked in that the procedure.
Right. There was a procedural failure.
All of those litigious filings that you got to file, somebody found a way to say, there's a procedural error. We have to let them out.
Right.
But
and didn't somebody misrepresent what you said? Because I thought I saw a comment on Twitter that you actually were against Hancock's execution, which I knew was not the case.
Right. So in the Christian Science Monitor piece, I don't know that I was a big fan of that piece. He spent too much time on McDougal and the posse. I was very glad that he spent a good amount of time talking, and so he put it in the piece about Craig Blankenship. Lawrence Anderson, the person. Right. That was the best part of that piece. And all I got was a little snippet about, I believe in, opportunity for grace kind of stuff. And, but I also said, when we had the vote for the death penalty in 2016, I said, I'm not in favor of the death penalty. I voted no because of this, the delay. I voted no because it takes so long for this to happen, the damage that it does to the victim survivors and their families. That was what I said. And the McAllister News quoted me, and I asked them immediately for a retraction, which they have yet to post, by the way. They quoted me as saying that I was there because I was against his execution.
Okay, yeah.
I was not against his execution. That was just the law. The law is what the law is. That's what we voted for. And moratoriums and all of these delays, the politicizing of protecting the public and public safety, this is where that posse of people now, including our Attorney General, they have sucked us into public safety issue, because bottom line, of all of the different policies that they argue about, this is the one that you cannot be politicizing, because public safety is about quality of life for people. Right. And if you're tinkering with the system, you're tinkering with a people's sense of feeling safe in their own home. And this is my standard argument about this. And so when you make families wait for, and in the Van Treese case, the Van Treese family, they're going on 28 years.
Yeah. Yeah.
Come on. This is crazy. And here's the best part about your podcast, going through all of these briefs where, people might be wondering, well, where's the meat and bones? No, you're demonstrating the meat and bones of this. The system's not broken. it's a very big system. It's lengthy. It permits far too much, I think, far too many filings. And now they have figured out all they have to do now at the end of the game is say, we have reason to believe this. If you accept our brief on this, it shows factual innocence. Because that phrase I heard finally for the first time, I heard it several times standing outside Big Mac while they were executing Phillip Hancock, because they didn't say he was factually innocent. They said he did the crime, but he was completely acting in self-defense. And the problem with that is these were people he knew he was dealing with. He went to their house. So, I mean,
right.
And so it's like, I don't know that I think that they just tried to use the self-defense because it helped. They were just trying to make an argument for their death penalty stuff. It was a very sad and somber day but at the same time, it was at least I don't know what, you never know for families if any of this brings them a measure of, you don't know how this helps. And so none of us can say, but what we can say, because you have your podcast that goes through this in finite detail, what we can say is that Phillip Hancock had a violent history. He had committed murder repeatedly. And then the last time he checked out in the free world, he really wasn't free, was he? He committed a double murder. And he got the death penalty for it. And so clearly you couldn't put him in prison for life. He would have killed somebody in prison.
Yeah.
And so you have to get into the weeds on this stuff. And they thought that saying self-defense was clearly warranted and it may be manslaughter at best. No way.
No.
Fuck no. Here's my F-bomb. I went all
one demerit.
There it was.
One demerit for you.
But the Mayo Clinic still says psychologically sometimes an F-bomb is okay.
Yeah.
No, because this is where politicians need to be careful about what they say, because if you say that a guy walking into another person coming onto another person's private property twice, uninvited, walking in the door, first of all, that's trespassing. You don't get to turn around and say, oh, well, these were biker people. And so, yeah, he was in fear of his life. No, the moment that Phil Hancock stepped on Mr. Jett's property, he was trespassing. He was committing a crime.
Well, I have to disagree with that. If Jett had said the minute he walked in the door that night, had said, get out.
Yeah.
That would have been the case. But he came in uninvited, but Jett kind of acquiesced.
Sure, he acquiesced.
And he hung out and he did some meth with him.
Sure.
So, everything was fine. But what happened was when Phillip Hancock got the gun, he went from victim to aggressor.
Right.
Because when he got the gun, Jett actually fled. And I think he was shot in the back the first two times.
Right.
So Jett had there in self-defense, if the person you believe you're defending yourself from ceases and retreats, then you go after him and kill him. That's no longer self-defense.
Right. Now
that becomes murder.
His version of the events is that Mr. Lynch, who is apparently overweight and disabled, had him in a chokehold. And then Mr. Jett was beating him with the metal pipe. So somehow you are already fairly restricted in the small confined area. And yet then it springs forward to he managed to get the gun and kill them both in self-defense.
Right.
It makes no sense whatsoever.
Right. And one of the reasons that didn't fly was because he claimed that he shot Lynch first by putting the gun right up against his abdomen.
Right.
And there was no gunshot residue or stippling
Right.
for such a close contact wound.
Correct.
And then Lynch also had a wound through his hand and in his face. And what they suspected was that Hancock got the gun, he shot Jett, and then he shot Lynch in the face and then in the abdomen. So, but yeah, he once he got control of that gun, he ceased to be a victim and became the aggressor.
Yeah, I'm not. I'm just so not a fan of what the politicians are doing with these cases. I mean, look, if you're going to start, if that's the way you want to roll with this, with the cowboy posse guys, then you need to do it with every death penalty case. Don't pick, just either or get a referendum.
This is my point. Their opinion about guilt or innocence or the process does not replace the court's opinions.
Exactly.
And that is where, see, this is the problem, and we saw it with Roberson. These legislators are now trying to supplant their opinions for the courts.
Invading the province of the courts. Isn't that what you said before?
That is, yes. That is pretty much it. That's what they're doing. And that's not right. And they're also undermining the courts.
Yes.
By saying, the court system's broken because it's not doing what we want it to do. It's not, it's not giving them due process because they're presenting these claims and losing. And I think procedural bars are one of the areas that they complain about. But you have to have that because you can't have somebody raise 3 on direct appeal and then raise 2 more on state post conviction, and then have 6 more things from the trial that they raise at a subsequent state post conviction, or that they try to raise for the first time on federal claims. That's the reason for procedural bars.
Right.
So that you raise everything that you have in a timely manner. But anyway, that's going into too far into the weeds.
No, I don't think so. I don't think so, because this was a case that the posse used as a olive branch to their gossip thing. And the irony of this is that I think Mr. Hancock's last words were that he thanked his attorneys. He called the AG an idiot.
Well, that's where I'm going. Last words to his attorneys. I want to thank you all for your support. You all have gone above and beyond the call of duty. Referring to the Attorney General in his office, it was self-defense all the way. You've been hoodwinked by Gettner Drummond, and they're vile, they're virtuous, they have no honor. This is insane. The drugs were administered at 11:17 a.m., and Hancock was pronounced dead at 11:29 a.m., and his death warrant was returned on 12/15/2023 by Oklahoma Department of Corrections.
And to that actually, what I found ironic was that actually the AG got this one right.
Yeah.
This was not self-defense. But Mr. Hancock, in the rest of that statement where he said, "You've all been hoodwinked," to the public.
Yeah. No, but the hoodwinking was the media and the clown posse. And I don't call them the cowboy posse. I call them the clown posse.
Well, and they're not so much a posse anymore, but he's right. Mr. Hancock was right, because we have been hoodwinked. We got hoodwinked with gossip by our own Attorney General. So that's why I think these things are important. am clearly coming to understand why it is that you guys have been doing this for so long. And really, it's you and Roberta, Mr. Sharp, and Martin. You guys are voices for the voiceless
Thank you.
in what you're doing. And when this came up with Julius Jones, and incidentally, then with Glossip, I'm not a podcaster. I haven't been I've been doing community, present to things in the community for a long time, while you guys have been doing this for so long. So it compelled me then to start being present to the situation, the executions or whatever was happening here in Oklahoma, because I do work in community safety. And you better believe that is that's my hot button issue.
Yeah.
And the minute I don't feel safe, the minute I feel powerless, where any layer of law enforcement has broken down, and when the attorney general of your state turns his back on a victim's family, like you did with the Van Treeses, that was a system breakdown in and of itself. Everyone to see it on live TV, and that scared me. But I knew I had to just, utilize whatever my skills were, whatever my compunctions were. I knew that in order to regain a sense of feeling secure, because at that moment when I saw that with Glossip, I felt powerless. I had to put my energy into that, and incidentally, it just was a phone call. But I mean, to me, that was my way of being a voice for victims.
Right.
In the same way that you guys are voices for the murder victims and their families, you're a voice for the system. So I'm just feel honored and grateful to know or have come to know you guys, and that you include me in, because you guys are just a wealth of knowledge and understanding about these cases.
Thank you.
That I take every advantage to pass on, to make sure that people aren't just reading taglines from the media.
Thank you. And I do, I really appreciate the support. I loved your shares for the Heyman Lee episode, which was the episode just before this one. Thank you so much for doing that, because, every little bit helps.
I mean, it's an interesting thing, because the anti-death penalty ideologues, they don't get into the weeds. They don't even get off the road. They just are like a traveling group of gypsies. They never get into the truth. They have what I guess you would say is my truth people.
Yeah, exactly.
And you can't get them to feel uncomfortable. They don't want to go there. And, I have no patience for people who don't have the moral fiber to get in the weeds. And, you guys have been hanging in for 20 years. I mean, my Lord, people don't realize that this kind of stuff has been going on forever.
Yeah.
And it gets scarier every day. And I don't even think, Dudley Sharp has put out so much information and statistics about this. I don't even know how his brain still works.
Yeah.
I mean, it's exhausting, but I just like everything that you guys have done, and I just hope that I'm to some extent making some kind of difference.
You are.
In some of the actions that I've taken. Because I damn sure wasn't going to let the AG turn his back on the Van Treese family. That was never going to fly with me. And to the extent that I was even going to remember, if you recall me asking you, I've got a master's degree. Surely I can write something to send to the Supreme Court. But that would have been a terrible thing to do. That would have been a disservice. So I got the advice from you guys that there was somebody to call. I made a phone call, and it turned out to be a fantastic phone call. Whether it works out in the favor of the Van Treeses, I think it already has, because they finally got a voice, and they got the best voice.
Yeah, it's kind of hard to see where the Supreme Court is going to land.
It is.
But I think, personally, I really don't think they have jurisdiction based on the fact that this is a state court decision.
Yeah.
Based on state procedural rules, and based on the fact that there is no actual violation, because those notes ultimately talked about what Snead told defense attorneys.
Exactly. Yeah.
And so the defense had that information. They didn't need the prosecutors. And that's another thing that's a problem for me. Brady, NAPU, that does not relieve defense attorneys from doing their own investigation and gathering their own information. And in this case, what really frustrated me with the oral arguments is that nobody, I like Mr. Michel, but he didn't say, when they were talking about, quote, Dr. Trumpet, he didn't say Glossop was represented by OIDS. They represent people in that jail. They are there all the time. They know, they're in that world, so they could have found that information themselves. Well, because they were saying the prosecutors, this is something known only to the prosecutors as far as the structure at the jail. And in reality, prosecution has no control over the jail.
Right. They don't get the sheets of paper from the sheriff saying, we got this guy on the bus here, right? We're transporting him. The defense had that all along. And to that point, it never said anything about being bipolar on that piece of paper. Just, it's amazing to be, when you get into the weeds also, even of oral argument stuff like that, how attorneys still lie through their teeth.
Yeah.
And so, no, nobody like me could write anything that could even stand a chance against seasoned attorneys that have stood before SCOTUS, a million times, all three of them, and including Mr. Cassell and Kent Scheidegger. There's no way. And so, what do you get for a family? Who do you call for a family like the Van Treeses, who have had zero voice in that conversation? Well, you have to call people like Paul Cassell, who it amazes me. Here's where the passage of time really, where you guys have been right about the passage of time, and the defense people depend on that, because then they can manipulate the media. Nobody knows that Paul Cassell represented Oklahoma City bombing victims. Not one person in the media has mentioned the Johnny Cochran of victims' rights people is representing the Van Treese family. Look, this guy's busy. So people want him from D.C. to Boeing to Jeffrey Epstein victims, right? And you'd think they would make a pretty big, and by the way, he represented Oklahoma City bombing victims. You would think that somebody in the media would mention that, like, oh, wait, now something must be up if this guy's in the conversation, because this guy's really busy a lot. But they didn't. They just called him like a law professor. I'm sitting there going, are you crazy? I know. But they got the best. And it sounds to me like, from your work on Phil Hancock's case, I don't know how much more representation he could have gotten.
No. And the problem is, and this is an old adage, when the facts are on your side, you argue the facts. When the law is on your side, you argue the law. When neither are on your side, aka Phil Hancock, you just argue. And that's what they did. I mean, the facts just were not on their side.
Well, then that's where Dudley is right when he says what's problematic about the system and in the state of Oklahoma is our Court of Criminal Appeals is that while they do often deny motions, the system has set itself up in a way that it's just circulatory. They just keep going and going, where they can just keep arguing and arguing.
Well, that's unfortunately they can't put a bar. And now we're going toward more general rather than, Phil Hancock specific. But yeah, they can't put a bar. So Don Knight can continue to raise these same things. And that's all it is. That's what the Reed Smith report was. That's what Rex Duncan's report is. It's just Don Knight re-arguing claims that have failed.
Yeah.
And trying to, repackage them in a way that's going to get Glossop off death row and a new trial. Because he knows he's probably already bribed Bahana, the new DA, not to even file the charge, to dismiss the charges. And then he probably thinks that he's going to sue the state of Oklahoma for bazillions of dollars for wrongful conviction of Richard Glossop. So that's what the end game is.
Sure. I don't see how that's going to work that way, but yes, you're right. But I just don't, I just don't see how that's going to happen. I mean, you just, it doesn't.
I don't believe that he's going to be successful, but that's what his plan is.
Yeah.
And that's why he keeps repackaging and re-arguing these things and painting them as serious constitutional violations.
Right.
So, but before I go on a rant about Don Knight,
that's a whole
and the clown posse, we're at 2 hours and 51 minutes.
Well, that's why your show is so good, though, because
thank you.
We
might want to wrap this one up now.
Oh, well, sure, we can, but we could talk for hours. But I appreciate you asking me to sub in for Kyle. You can ask me anytime, especially if it's a case. And I did talk to the Van Treeses after I talked to Derek after, and he had time to sort of go over it with Mr. Cassell, and the only thing I said to him, I said, really, the only thing that's important for me to ask you is, do you feel bad? Do you feel like you have a voice? Did you have a voice? Did you feel like you had a voice? And, he was probably, I don't know. He said, yes, Mom and I feel pretty good about it. So if that's just a scintilla of, I did the right thing, and incidentally, Connie Smotherman, did the right thing. He was making those phone calls. Then that makes me feel better.
Yeah.
Because in no way should anybody ever, no victim, survivor, families should ever, ever, ever be put in that kind of position. And this shit, like with Hancock and Glossop and the let's just call them the clown posse. I'm going to go with Craig Blankenship. Are you willing to bet your family on it?
Right.
Not me.
All right. I'm going to go ahead and wrap up. Thank you again, Jennifer, for joining me.
Thank you.
It was wonderful. And as always, your insight is just, the public safety aspects, sometimes I don't even think about that. But you tie it into this one case has an impact on overall public safety. And that's true, because they want to release somebody who every time he feels threatened, he just kills them.
Correct.
And thinks, okay, well, I didn't do anything wrong because I felt threatened.
Mm-hmm.
And with his dying breath. So let me say he didn't get right with his maker at all. Although apparently he was an atheist.
I don't know. I don't know. I believe he
So,
went. I think he went to meet his maker, and I said Godspeed to him in the same way that I would have anybody else, and so that's a providentially ordered argument that I won't get into, and I'm okay with that. And but people should think about that. What you're saying, when I never consider it about public safety. People should. It is what Craig Blankenship said. Are you willing to bet your family on it? It's like that line from A Few Good Men, where Tom Cruise asked Demi Moore, why do you like those guys so much? And she says, because they stand on a wall and they say nothing's going to happen to you. Well, these are people in our state government who are standing on the wall, and they've got the keys, and they want to turn the key, and they want to open up and let them out. And we already did that with that mass commutation, and more people were murdered. So that should scare people. That really should scare people. That should scare people to stop thinking about what Trump or Kamala is wearing on one day or another and why they shouldn't be elected. No, this is real hardcore stuff. Like when you walk out your door, do you know what's going to happen if you get murdered? Is your family going to have to wait 27 years like the Van Treeses before the justice that has been adjudicated and promised them will ever be actually adjudicated?
Yeah. All right.
And I could go on forever.
No. And I would love you too, but it's after 6:00 on Sunday night.
But you're right. I hope I do add insight. I hope
you do, and you really do. And I don't mean to. I feel bad, but we get to a certain point where you get tired, I get tired, the listeners get tired, and we can pick this up another time.
But you know what? That's the deal, though. This kind of work is not easy.
No, it isn't.
And if somebody can't hang for 2 hours or 3 hours, then they need to consider what they're doing when they're forcing people like the Van Treese family to wait for 27 years.
Yeah.
So.
All right.
But thank you again. I'm just honored.
Thank you.
Tell Kyle I said hello. Hope him and his family are doing well, and I know you're doing well, and to stay in touch.
I will.
Okay.
So you can stick around. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and guest host Jennifer Harmon. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLAnt. Kyle and I will return in 3 weeks for episode 16, State of Texas versus Robert Leslie Roberson III. In 2003, Roberson was convicted of capital murder in connection with the 2002 death of his 2-year-old daughter, Nikki Curtis. Roberson was scheduled to be executed on October 17, 2024, but at the 11th hour, Texas legislators stepped in and were able to get a stay of execution issued by the Texas Supreme Court, which has no jurisdiction over criminal matters in Texas or the power to stop executions, which rests solely with the Texas Court of Criminal Appeals. I'll be joined by guest Mitch Little to talk about the evidence against Roberson, his legal challenges to the conviction, and the still developing case at the Texas Supreme Court. Mr. Little is a successful business attorney and candidate for state representative in House District 65 in Texas. Until then, have a great 3 weeks and stay safe.